So today we're going to be going over the case of affirmative action, how it was overturned recently. I find it very interesting and fascinating to observe the conclusions of the two black justices and how they had totally different opinions and conclusions on why we should overturn it or why we should maintain it. Supreme Court Justice Clarence Thomas concurred that it should be overturned. I'm going to read off his opinion and justifications for removing it. And also, I'm going to read Ms. Jackson's Supreme Court, the newest Supreme Court Justice that we have, Ms. Jackson. So, this is very eye-opening for me personally and anyone that's watching, because we must understand that these are two, obviously, African Americans that are 50 and above. They definitely had a lineage of African American slavery ancestry of this nation. They both saw or experienced blatant discrimination. Their parents and grandparents experienced discrimination. So it's interesting to see that they have a similar upbringing, similar race, yet their conclusions and reasonings for support is completely different. One supports it, one does not support it. And this split that we're going through right now, that we see between two black Supreme Court justices, is an example of a split that we see also in the nation and also in the black community. So these discussions must be had on the mass scale, on the cultural, the educational fabric of this nation. And I should start by first defining what affirmative action is. Affirmative action is a policy or set of procedures that aims to improve the educational or employment opportunities of certain demographic groups that have been historically discriminated against or underrepresented in society. It gives limited preferences to qualified groups based on criteria such as race, gender, ethnic origin, disability, and age. Affirmative action was initiated by U.S. government in the 1960s as a remedy to the effects of long-standing discrimination. Affirmative action is sometimes called positive discrimination. I'm going to give my opinions as we go. I'm not going to tell you where I stand on this. I'm just going to approach this in a blank slate, a blank canvas. This is just an experiment to truly dissect and understand all arguments, both arguments. We're just going to be looking at Clarence Thomas and Supreme Court Justice Jackson, Ms. Jackson, and that is all. So, reading it directly, it seemed like the reasoning behind this in the 1960s, positive discrimination, that's a very interesting way of reframing racism or reverse racism or revenge or giving someone privileges while taking away from somebody else. In other words, if it's not equal, then it's not equal for everybody. If it's not equal for everybody and it's only equal for somebody else has to take the short end of the stick. That's my immediate thought on this. And the whole mindset that affirmative action implies, the whole premise of it is that it is justified because we must correct the discrimination and past tragedies of women and black Americans. Because the assumption also is that the federal government, the Constitution, needs to be used to correct these past discriminations and great errors that was allowed in this nation, I'm trying to put myself in all the shoes, the side of agreeing with this and the side of disagreeing with this. And the side of agreeing with this, if I was truly in the belief that we must correct past, we must use some sort of systematic enforcement to correct the past things, that the system in itself, the laws in themselves, also were used to enforce this blatant discrimination, this obvious setbacks that was imposed to black people and women as well. But it was mostly for the correction for African Americans. It's an interesting conclusion that we must use the same mindset that was used to bring black folks down to also use it in the same way, which is using race in the eyes of the law to bring and correct the things of the past. Either way, you're still putting a emphasis on race and judgment on race and having preferential treatment under the guise of, well, we're doing this to correct the past. Positive discrimination. I'm sure there was a lot of consequences that we did not foresee on this, that the last 30 to 40 to 20 years, we are seeing consequences, which is why it is back in the Supreme Court. All right, so Clarence Thomas, in the wake of Civil War, the country focused its attention on restoring the Union and establishing the legal status of the newly freed slaves. The Constitution was amended to abolish slavery and proclaim that all persons born in the United States are citizens, entitled to the privileges or immunities of citizenship and the equal protection of the laws. Because of that second founding, it's very interesting. The second founding, which is basically a complete revolution, a paradigm shift that happened in this particular timeline of how the nation needs, what the nation needs to move forward, to make progress. Because of the second founding, our Constitution is colorblind and neither knows nor tolerates classes among citizens. Plessy v. Ferguson. This court's commitment to that equality principle has ebbed, I'm not saying that right, and flowed over time, ebbed and flowed over time. After forsaking the principle for decades, offering a judicial imprimatur to segregation, and ushering in the Jim Crow era, the court finally corrected course in Brown v. Board of Education, announcing that primary schools must either desegregate with all deliberate speed or else close their doors. Brown v. Board of Education, 1955. It then pulled back in the Grutter v. Bollinger, permitting universities to discriminate based on race in their admissions process, though only temporary, in order to achieve alleged educational benefits of diversity. Yet the Constitution continues to embody a simple truth. Two discriminatory wrongs cannot make a right. It's very interesting. This really challenges the whole premise of affirmative action. It challenged it all, which affirmative action genuinely believes that one wrong, while it is justified, it is okay because of the past wrongs. In other words, two wrongs do make rights. Are the means of it is justified. It is okay to do. Clarence Thomas disagrees. Two discriminatory wrongs cannot make right. I wrote separately in Grutter explaining that the use of race in higher education admissions decisions, regardless of whether intended to help or to hurt, violates the 14th Amendment. Opinion occurring in the part of the dissenting in the part in the decades since, I have repeatedly stated that Grutter was wrongly decided and should be overruled. Today, and despite a lengthy interregnum, probably saying that wrong, the Constitution prevails. Because the court today applies genuine strict scrutiny to the race-conscious admission policy employed at Harvard and University of North Carolina, and finds that they fail that searching review. I join the majority opinion in full. I write separately to offer an originalist defense of the colorblind Constitution. You're going to see this word pretty often, colorblind. An originalist, which is what Clarence Thomas is, which is an emphasis of how you interpret the Constitution. It's pretty fascinating. I'm going to go probably make another separate video on that. To explain further the flaws of the court's Grutter jurisprudence, to clarify that all forms of discrimination based on race, including so-called affirmative action, are prohibited under the Constitution, and to emphasize the pernicious effects of all such discriminations. So Clarence Thomas is making the argument it is not that it goes against the 14th Amendment, that two wrongs, two discriminations cannot make a right, and that it is a pernicious solution. In the 1860s, Congress proposed and the Senate ratified the 13th and 14th Amendment, and with the authority conferred by these amendments, Congress passed two landmark civil rights acts. Throughout the debate on each of these measures, their proponents repeatedly affirm their view of equal citizenship and the racial equality that flows from it. In fact, they held this principle so deeply that their crowning accomplishment, the 14th Amendment, ensures racial equality with no textual reference to race whatsoever. The history of these measures' enactment renders their motivating principles as clear as their text. All citizens of the United States regarding skin color are equal before the law, which is really what the question is. Under the eyes of the law and the eyes of the Constitution and what's written within the Constitution, does it say any type of preferences or corrections or either or, no matter where you're coming from? Does the Constitution allow for any type of racial preferences, discrimination, positive discrimination, whatever phrase you want to use? It doesn't matter. I do not contend that all of the individuals who put forth and ratified the 14th Amendment University believe this to be true. Some members of Congress, for example, opposed the amendment, and the historical record, particularly with respect to the debates on ratification in the states, is sparse. Nonetheless, substantial evidence suggests that the 14th Amendment was passed to establish the broad constitutional principle of full and complete equality of all persons under the law, forbidding all legal distinctions based on race and color. This is a strong argument, because this is talking about the intent, the words used within the 14th Amendment. It's clear and direct to completely eliminate the distinctions based on race and color on all directions in every single state and every single situation under the law and the federal Constitution. This was Justice Harlan's view on his lone dissent in the Plessy, where he observed that our Constitution is colorblind. So Justice Harlan is nicknamed the Great Dissenter. There's a book on that. The Great Dissenter. His name is Justice John Marshall Harlan. He was a white man. And this is around the 1950s, if I'm right. So, and he was the only Supreme Court justice that dissented. And he was one of the first to use the phrase colorblind, where he observed that our Constitution is colorblind. It was the view of the court in Brown, which rejected any authority to use race as a factor in affording educational opportunities. And it is the view adopted in the court's opinion today, requiring the absolute equality of all citizens under the law. In 1864 election platform, the Republican Party pledged to amend the Constitution to establish the utter and complete extirpation of slavery. The soil of the Republic. After their landslide victory, Republicans quickly moved to make good on that promise. Congress proposed what would become the 13th Amendment to the states in January 1865, and it was ratified as part of the Constitution later that year. The new amendment stated that neither slavery nor involuntary servitude shall exist in the United States, except as punishment for a crime whereof the party shall have been duly convicted. It is thus not only prohibited states from themselves enslaving persons, but also obligated them to end enslavement by private individuals within their borders. Its framers viewed the text broadly, arguing that it allowed Congress to legislate not merely against slavery itself, but against all the badges and relics of slave systems. The amendment also authorized Congress to enforce its terms by appropriate legislation authority not granted in any prior amendment. Proponents believe that this enforcement clause permitted legislative measurements designed to accomplish the amendment's broader goal of equality for freed men. So there's a lot of people that have the theory that the founding fathers, when they ratified the Constitution and they all signed it, they signed the Bill of Rights, etc., did not, just a theory, I'm not sure how factual it is, that they really didn't believe at the timeline of the ratifying of the Constitution that it was not possible for the Union to come together, the 13 colonies to come together, if slavery, especially in the South, if slavery was not going to be authorized. There was a lot of states, especially in the North, that disagreed with the dependence of slavery. They wanted to abolish it. Not all states. The country was still young and very dependent on slavery. And we were still new. And that we had different economic needs depending on your area and location. The South was primarily focused on cotton, agriculture, farming jobs, and they required and needed cheap labor, free labor. It was extremely profitable. There was a lot of money to be made, and the economies in that particular timeline in the South revolved around that system. So, just giving you guys full context. A lot of people just want to jump to conclusion and not get full context of why things were the way they were in a particular timeline, the history and founding of this nation. And, you know, there was a lot of propaganda in that particular timeline to justify, continue the slave, right? Enslaving the black man that we got from the transatlantic slave trade, and also indigenous Indians in that land were slaves too. But the theory continues that while the founding fathers knew that this was something that needed to be handled, they knew that it was not going to happen in their lifetime. It just wasn't possible. So they had to compromises. They had a lot of compromises. There were so many compromises to get people to get the Union to unite, to establish a big picture of it being its own established country that breaks away its dependence and need of the British Empire after winning the Revolutionary War, for example. And one of the concessions that they knew just wasn't possible was the ability to abolish slavery. Just wasn't possible in that particular timeline. And to finish off here, the theory states that the one thing they could do was, well, we don't have to put it in the Constitution that, for example, that all men are created equal. They could have said all white men are created equal. They could have said all pilgrims and free men at the current time are created equal. They could have said something that those from Africa, the current slaves and the descendants thereof, are not created equal. There's a lot of things they could have said in the founding of this nation and the ratifying of the Constitution that could have brought up some specific of white superiority and black inferiority. But you don't see that. So one can say that they did that on purpose because their long-term vision and hope for writing the Constitution in this way was that it was going to allow for interpretation and Supreme Court justices and for it to mature to the point where it can be used to say it's not a constitutional right. Reading the Constitution in its literal sense, the Constitution is colorblind. It makes clear that all men are created equal. It's an interesting theory. Very interesting theory. I don't know. I'm not sure. Because those people can make the counter argument and say, well, whoever interprets the Constitution of its historical context and its original intent of how it was written, whenever they said all men are created equal, they were talking specifically about the white men in that specific time. That's a counter argument that is reasonable, because there's a lot of times that people will interpret the Constitution in what they meant when they wrote the word itself, all men. All men in this specific time, as I'm writing this, that are freed, are they equal? Or is it all men in the land of America? Right? This is when you see debates and discussions between different Supreme Court justices, this is how they have discourse and disagreements and discussions about what was meant in the text and what's the original intent and the definition of the word whenever it was written, because words can progress and change as well. It's so fascinating. I love trying to understand that stuff and see how people can come to different conclusions. But anyways, I'm digressing now. Back to the main subject at hand, but it's just something to think about, because whenever Clarence Thomas makes the case here, he's making the case that the Constitution, read literally, was meaning that all men are created equally. Let's continue. It quickly becomes clear, however, that further amendment would be necessary to safeguard that goal. Soon after the 13th Amendment adoption, the reconstructed southern states began to enact black codes. So it's very obvious. Like I said, whenever you study the past, it's very obvious that the South had a strong dependency on slavery. And, you know, it's very interesting what humans will do to justify their behavior when their main objective is to just make a lot of money, to live a good life. They'll do some catastrophic things when you look at it. But in reality, majority of history is there's a lot of slavery. Slavery was common practice. Slavery was a common, one can say, necessary evil that our ancestors went through. We see it in Egypt. We see it in the Roman Empire. We see it for most big established empires, the Persian Empire. They had slaves. Now, slaves has a multitude of different meanings, like indentured servitude, paying off a debt, simply, working for someone. They just give you your basic necessities and needs. Some people willfully became slaves to pay off debts or achieve an objective, or it's a very interesting subject. It's not as simple as how we see it in the American context of it, of white supremacy and the lynchings and the beatings and yada yada yada. It's just something to think about. All right, so black codes. This is a very interesting and controversial topic here. Black codes was definitely used in the South, and the South was very stubborn in their ability to get out of the white supremacy mindset and dependency of having slaves. You're messing with the federal government was messing with the South's livelihood, their economy. That for generations, that was the standard and norm. And what really the federal government was asking for is to collapse their economy, collapse their ability to make ends meet. After the Civil War, the South went through a Great Depression. This is very interesting how dependent the South was for it. All right. So soon after the 13th Amendment adopted, the reconstructed Southern states began to enact the Black Code, which circumscribed the newly won freedoms of blacks. The Black Code of Mississippi, for example, imposed all sorts of disabilities on blacks, including limiting their freedom of movement and barring them from following certain occupations, owning firearms, serving on juries, testifying in cases involving whites, or voting. Congress responded with the landmark Civil Rights Act in 1866, an attempt to preempt the Black Codes. The 1866 Act promised such a sweeping form of equality that it would lead many to say that it exceeded the scope of Congress's authority under the 13th Amendment. As enacted, it stated, "Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States, and such citizens of every race and color, without regard to any previous condition of slavery or involuntary servitude, except as punishment for crime whereof the party shall have been duly convicted, shall have the same right in every state and territory in the United States to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property, as is enjoyed by white citizens, and shall be subject to like punishment, pains, and penalties, and to none other, any law, statute, ordinance, regulation, or custom to the contrary, notwithstanding. The text of the provision left no doubt, end quote. The text of the provision left no doubt as to its aim. All persons born in the United States were equal citizens entitled to the same rights and subject to the same penalties as white citizens in the category enumerated. Thomas continued, forbade racial discrimination generally, nor did it guarantee particular rights to all persons. Rather, it required an equality in certain specific rights. And while the 1866 Act used the right of white citizens as a benchmark, its rule was decided colorblind, safeguarding legal equality for all citizens of every race and color, and providing the same rights to all. The 1866 Act evolution further highlights its rule of equality. The start of Dred v. Sanford, 1857, had previously held that blacks were not regarded as portion of the people or citizens of the government, and had no right which the white man was bound to respect. The act, however, would effectively overrule Dred Scott and ensure that equality had been promised to blacks. But the act went further still. On January 29, 1866, Senator Trumbull, the bill's principal sponsor in the Senate, proposed text stating that all persons of African descent born in the United States are hereby declared citizens. The following day, Trumbull revised his proposal, removing the reference to African descent and declaring more broadly that all persons born in the United States and not subject to any foreign power are citizens of the United States. In the years before the 14th Amendment adoption, jurists and legislators often connected citizenship with equality, where the absence of presence of one entailed the absence of presence of the other. Absence or presence of the others. The addition of citizenship guarantee thus evidence an intent to broaden the provision extending beyond recent freed blacks and incorporating a more general view of equality for all Americans. Indeed, the drafters later included a specific carve-out for Indians not taxed, demonstrating the breadth of the bill, otherwise general citizenship language. As Trump would explain, Senator Trumbull, the provision created a bond between all Americans. Quote, any statute which is not equal to all, and which deprives any citizen of civil rights which are secured to other citizens, end quote, was, quote, an unjust encroachment upon his liberty, end quote, and a badge of servitude, prohibited by the Constitution. Trumbull and most of the Act's other supporters identified the 13th Amendment as a principal source of constitutional authority for the Act's non-discrimination provisions. In particular, they explained that the 13th Amendment allowed Congress not merely to legislate against slavery itself, but also to countermeasure which deprive any citizen of civil rights which are secured to other citizens. It's so interesting to see the maturation, the blossoming, the enlightening that is taking place which is why a lot of people think that the founding fathers foresaw this or hoped for this. Because when you look at the literal text itself, if you really want to test the authority and consistency of the Constitution, you must live up to the document itself. If we are to be bound and honor the Constitution and the founding fathers and what took place with ratifying of the Constitution, we must not be hypocrites of the Constitution and honor it and respect and submit to the authority and wisdom that was put upon the Constitution, the faith that was put upon into the Constitution. The Supremacy Clause, which simply means that the Constitution is the law of the land. It takes precedent over any other law and also takes precedent over a lot of key important things that states cannot challenge. So when you look at people making arguments in support and coming to the colorblind conclusion, it all stems from how the framers worded the Constitution. And never do you see words or preferences of discrimination between the white man, black folks, Negro, anything of that nature. No type of colorism or tribalism was imposed within the Constitution, even though when the Constitution was ratified, there was still plenty of that within our nation. It's honestly brilliant when you look at it. I don't know how it was achieved, but that's what I see as I read into the arguments of Clarence Thomas, which is, again, the ideal, the vision, the long-term vision that can be interpreted as you read the words, the specific words, the precise words used, is that they desired for a colorblind society. In particular, they explain the 13th Amendment allowed Congress not to merely to legislate against slavery itself, but also to counter measures. Yeah, I just read that. But opponents argued that Congress authority did not sweep so broadly. President Andrew Johnson, for example, contended that Congress lacked authority to pass the measure, seizing on the breadth of the citizenship text and emphasizing state authority over matters of state citizenship. Consequently, doubts about the constitutional authority conferred by the measure led supporters to supplement their 13th Amendment arguments with other sources of constitutional authority. R. Williams, Originalism and the Other Desegregated Decision, describing appeals to the naturalization power and the inherent power to protect the rights of citizens. As debates continued, it became increasingly apparent that safeguarding the 1866 Act, including its promise of black citizen and the equal rights that citizenship entailed, would require further submission to the people of the United States in the form of proposed constitutional amendment. Critically, many of those who believe that Congress lacked the authority to enact the 1866 Act also supported the principle of racial equality. So almost immediately following the ratification of the 13th Amendment, several proposals for further amendments were submitted in Congress. One such proposal, approved by the Joint Committee on Reconstruction and then submitted to the House of Representatives on February 26, 1866, would have declared that the Congress shall have power to make all laws which shall be necessary and proper to secure to the citizen of each state all privileges and immunities of citizen in the several states, and to all persons to several states equal protection and the right to life, liberty, and property. Representative John Bingham its drafter was among those who believed Congress lacked the power to enact the 1866 Act. Specifically, he believed that very letter of the Constitution already required equality, but the enforcement of that requirement is of the reserved powers of the states. It's an interesting predicament here. So we understand that the Constitution already required equality, but how are they going to enforce that? Because it says here, enforcement of that requirement is reserved to the powers of the states. Its proposed constitutional amendment accordingly would provide a clear constitutional basis for the 1866 Act and ensure that future Congresses would be enabled to repeal it. Discussion of Bingham's initial draft was later postponed in the House, but the Joint Committee on Reconstruction continued its work. The Reconstruction Amendments 8. In April, Representative Stevens proposed to the Joint Committee an amendment that began, "No discrimination shall be made by any state nor by the United States as the civil rights of persons because of race, color, or provision or previous condition of servitude." Reprinting the Journal of Joint Committee on Reconstruction of the 39th Congress. Stevens' proposal was later revised to read as follows: "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive of any person of life, liberty, and property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." This revised text was submitted to the full House on April 30th, 1866. Like the eventual first section of the 14th Amendment, this proposal embodied the familiar privileges or immunities due to process and equal protection clauses. And importantly, it also featured an enforcement clause with text borrowed from the 13th Amendment, conferring upon Congress that the power to enforce its provisions. Stevens explained that the draft was intended to allow Congress to correct the unjust legislation of the states, so far that the law which operates upon one man shall operate equally upon all. Moreover, Stevens' later statement indicated that he did not believe there was a difference in substance between the between the new proposal and earlier measures calling for impartial and equal treatment without regard to race. And Bingham argued that the need for a proposed text was one of the lessons that have been taught by the history of past 4 years of terrific conflict during the Civil War. The proposal passed the House by a vote of 128 to 37. Senator Jacob Howard introduced a proposed amendment in the Senate, powerfully asking, "Ought not the time to be now passed when one measure of justice is to be meted out to a member of one caste, while another indifferent measure is meted out to a member of another caste, both castes being alike citizens of the United States, both bound to obey the same laws, to sustain the burdens of the same government, and both equally responsible to justice and to God for the deeds done in the body." In keeping with this view, end quote. In keeping with this view, he proposed an introductory sentence declaring that, quote, "All persons born in the United States and subject to the jurisdictions thereof are citizens of the United States and of the states wherein they reside." End quote. This text, the Citizenship Clause, was the final missing element of what would ultimately become become the 14th Amendment. Howard's draft for the proposed citizenship text was modeled on the Civil Rights Act of 1866 text, and he suggested the alternative language to remove all doubts as to what persons are or are not citizens of the United States. A question that which had long been great desideratum. I'm not saying that right. I'm not saying that right. In the jurisprudence and legislation of this country. End quote. He further characterized the addition as, quote, simply declaratory of what I regard as the law of the land already. The proposal was approved in the Senate by a vote of 33 to 11. The Congress then reconciled differences between the two measures, approving the Senate's challenges by a vote of 120 to 32. And in June 1866, the amendment was submitted to the states for their consideration and ratification. 2 years later, it was ratified by the requisite number of states and became the 14th Amendment of the United States of America. Its opening words instilled in our nation's Constitution a new birth of freedom. Quote, this is the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisprudence thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. These amendments are so important for us to study and understand. These are your rights. This is how we came to be now. And we should be thankful for the people within this timeline, the senators, the congressmen that were fighting to truly equalize and create a colorblind society in the eyes of the Constitution, which took a while to reflect downward, to trickle downward to the states and also to the culture. Clarence Thomas continues. Let me get some water. I'll be right back. As enacted, the text of the 14th Amendment provides a firm statement of equality before the law. So really what Clarence Thomas is doing here is he's making a strong case of the constitutionality of the 14th Amendment, the constitutionality of affirmative action. Is affirmative action constitutional? Why is it not constitutional? Why it should be abolished? And he's making a very strong case of saying that the second founding, the 13th Amendment, the 14th Amendment, what it took to truly reverse and break away the colorness, the tribalism, the race and color being a huge indicator under the eyes of the law, being an old way of thinking, something that should no longer be used. The text of the 14th Amendment provides a firm statement of equality before the law. It begins by guaranteeing citizenship status, invoking the long-standing political and legal traditions that closely associated with the status of citizenship with the entitlements to legal equality. It then confirms that states may not abridge the right to the national citizenship, including whatever civil equality are guaranteed to the citizen under the Citizenship Clause. Finally, it pledges that even non-citizens must be treated equally as individuals and not as a member of racial, ethnic, or religious groups. So this is why illegal citizens, when they come to this land, even though they're not citizens, they can still be treated equally as well, which is a controversial topic because a lot of people think that citizenship should be take priority over non-citizens. So, the drafters and ratifiers of the 14th Amendment focus on this broad equality idea, offering surprisingly little explanation of what terms was intended to accomplish which part of the amendment's overall goal. The available materials show, however, that there were widespread expressions of general understanding of the broad scope of the amendment, similar to that abundantly demonstrated in the congressional debates, namely that the first section of the amendment would establish the full constitutional right of all persons to equality before the law and will prohibit legal distinctions based on the race or color. For example, the Pennsylvania debate suggested that the 14th Amendment was understood to make the law what justice is representative to be blind to the color of one's skin. The most commonly held view today, consistent with the rationale repeatedly invoked during the congressional debates, is that the amendment was designed to remove any doubts regarding Congress' authority to enact the Civil Rights Act of 1866 and to establish a non-discrimination rule that cannot be repealed by future Congress. J. Harrison, Reconstructing the Privileges of the Immunities Clause, 1992, noting that primary purpose of the 14th Amendment was to mandate certain rules of racial equality, especially those contained in Section 1 of the Civil Rights Act of 1866. The amendment's phrasing supports this view, and there does not appear to have any argument to the contrary predating Brown. Consistent with the Civil Rights Act of 1866 aim, the amendments definitively overruled Chief Justice Taney's opinion in Dred Scott that blacks were not regarded as a portion of the people or citizens of the government. This is interesting. Chief Justice Taney of Dred Scott was his dissenting opinion. This is one view, one conclusion of the Supreme Court justice at a particular timeline. Quote, were not regarded as a portion of the people or citizens of the government and had no rights which the white man was bound to respect. And like the 1866 Act, the amendment also clarified that American citizenships conferred. There is some support in the history of enactment for at least 4 interpretations of the first section of proposed amendment, and in particular its own privileges or immunities clause. It would authorize Congress to enforce the privileges and immunities clause of Article. It would forbid discrimination between citizens that respect the fundamental rights. It would establish a set of basic rights that all citizens must enjoy. It would make the Bill of Rights applicable to the states. D. Curry, the Reconstruction Congress. Notably, those 4 interpretations are all colorblind. You're going to see that word very, very often. Colorblind, colorblind, color neutral. All right. Clarence Thomas continues. Rights not just against the federal government, but also the government of citizen state of residence. Unlike the Civil Rights Act, however, the amendment employed a wholly race-neutral text extending privileges or immunities to all citizens, even if its practical effects was to provide all citizens with the same privileges than enjoyed by whites. That citizenship guaranteed was often linked with the concept of equality, combining the citizenship guarantee with the privileges or immunities clause and the equal protection clause. The 14th Amendment ensures protection for all equal citizens of the nation without regard to race. Put succinctly, our Constitution is colorblind. In the period closely following the 14th Amendment's ratification, Congress passed several statutes designed to enforce its terms, eliminating government-based black code systems of government-imposed segregation and criminalizing racially motivated violence. The marquee legislation was the Civil Rights Act of 1875, and the justification offered by proponents of that measure also further evidence for the colorblind view of the 14th Amendment. The Civil Rights Act of 1875 sought to counteract the systems of racial segregation that had arisen in the wake of the Reconstruction era. Advocates of so-called separation but equal systems, which allowed segregation facilities for blacks and whites, had argued that the law permitting or requiring such segregation treated members of both races precisely alike. Blacks could not attend a white school, but symmetrically, whites could not attend a black school. Circumstances at the time, racial segregation did not necessarily imply the inferiority of either race to the other. Congress was not persuaded. Supporters of the soon-to-be 1875 Act successfully countered that symmetrical restriction did not constitute equality, and they did so on colorblind terms. For example, they asserted that free government demands the abolition of all distinctions founded on color and race, and they submitted that the time has come when all distinctions that grew out of slavery ought to disappear. As long as you have distinctions and discriminations between white and black and the enjoyment of legal rights and privileges, you will have discontent and parties divided between black and white. Leading Republican Senator Charles Sumner compellingly argued that any rule excluding a man on account of his color is an indignity, an insult, and a wrong. Quote, I insist that by law of the land, all persons without distinction of color shall be equal before the law. End quote. Far from conceding that segregation would be perceived as inoffensive if race roles were reversed, he declared that this is plain oppression, which you would feel keenly were it directly against you or your child. He went on to paraphrase the English common law rule to which he subscribed. The law makes no discrimination on account of color. Others echoed this view. Representative John Lynch declared that the duty of the lawmaker is to know no race, no color, no religion, no nationality, except to prevent distinctions or any of these grounds so far as the law is concerned. Senator John Sherman believed that the route to peace was to wipe out all legal discrimination between white and black, and to make no distinction between black and white. All in the lines of colorblindness, clearly. And Senator Henry Wilson sought to make illegal all distinctions on color on account of color because there should be no distinctions recognized by the laws of the land. Men are formed of God equally. The Civil Rights Bill simply declares this, that there shall be no discrimination between citizens of this land so far as the laws of the land are concerned. The view of the legislature was clear. The Constitution neither knows nor tolerates classes among citizens. The early Supreme Court opinions to interpret the 14th Amendment did so in colorblind terms. Their statements characterizing the amendment evidence its commitment to equal rights for all citizens, regardless of their skin color. In the Slaughterhouse case, the court identified the pervading purpose of the Reconstruction Amendments as the freedom of the slave race, the security and firm establishment, the freedom and protection of the newly made free man and citizen was from the oppression of those who had formerly exercised unlimited dominion over him. Yet the court quickly acknowledged that the language of the amendments did not suggest that no one else but the Negro can share in this protection. Rather, if Mexican peonage or the Chinese coolie labor system shall develop slavery of the Mexican or Chinese race within our territory, the 13th Amendment may safely be trusted to make it void. And similarly, if other rights are assailed by the states which properly and necessarily fall within the protection of these articles, that protection will apply, though the party interested may not be African descent. The court thus made clear that the 14th Amendment's equality guarantee applied to Congress of all races, including Asian Americans, ensuring all citizens equal treatment under the law. 7 years later, the court relied on the Slaughterhouse view to conclude that the words of the 14th Amendment contain a necessary implication of positive immunity or rights most valued to the colored race. The right to exemption from unfriendly legislature against them distinctly as colored. The court thus found that the 14th Amendment banned express racial classification, no matter the race affected, because these classifications are a stimulant to race prejudice. As the Constitution which authorized them was to place the colored race in respect of civil rights upon a level with whites. They made the rights and responsibilities, civil and criminal, of the two races exactly the same. One great purpose of the 13th Amendment, 14th Amendment was to raise the colored race from that condition of inferiority and servitude in which most of them had previously stood into perfect equality of civil rights with all other persons within the jurisdiction of the states. So really, when you see what Clarence Thomas is saying here, and why he's using these different instances and senators' opinions and different opinions about court cases, dissents, etc., etc., he's painting the picture, the common narrative, the general consistent theme that we have moved past this. We shouldn't resort or go back to inferiority or seeing them as inferior, seeing anyone as inferior. There was a time that the Negro race, the black race, the African race, the slave men in this nation were seen as inferior, less than. not respectable, not worthy, not persons, but property. And you can see there was a paradigm shift that happened in this nation, blatantly, obviously, when the 14th and 13th Amendment were passed. And he just continues and hammers this point over and over and over again. Like I said, I read this yesterday. So if you want to continue to read this, go to on the top right. You should see it right here. But I'm going to skip through here through some of the juicy stuff where he starts going after the opinions and conclusions of those that dissent on Clarence Thomas and his final opinion and how the Constitution should be used to correct the things of the past, which is what you're going to see as the common theme of the opposing Supreme Court justices that dissent, like Miss Jackson. Despite the extensive evidence favoring the colorblind view, as detailed above, it appears increasingly in vogue to embrace an anti-subordination view of the 14th Amendment, that the amendment forbids only laws that hurt but not help blacks. Yeah. This is interesting because now he's starting to really attack the premises and the assumptions and justifications, which is that the 14th Amendment is not enough, that just simply equalizing everyone and making an equal playing field for everyone and no longer viewing the African American person as less than or inferior is not enough. And he's saying here that such theories lack any basis in the original meaning of the 14th Amendment. So you're going to see this often. Original meaning. Clarence Thomas is an originalist. Whenever he talks about original meaning, what we just went through these recent paragraphs is him hammering that point of the original meaning and intent of those who wrote the 13th and 14th Amendment. Respondents cite a smattering of federal and state statutes passed during the years surrounding the ratification of the 14th Amendment. And Justice Sotomayor's dissent argues that several of these statute evidence that the ratifiers' understanding that the Equal Protection Clause permits consideration of race to achieve its goal. Upon examination, however, it is clear that these statutes are fully consistent with the colorblind view. So now we are seeing a disagreement in interpretation. Start with the 1865 Freedmen Bureau Act. That act established the Freedmen Bureau to issue provisions, clothing, and fuel needful for the immediate and temporary shelter and supply of destitute and suffering refugees and freedom of their wives and children, and the setting apart for the use of loyal refugees and freemen, abandoning confiscated and purchased lands, and assigning to every male citizen, whether refugee or freeman, not more than 40 acres of such land. The 1866 Freedmen Bureau Act then expanded upon the prior year's law, authorizing the Bureau to care for all loyal refugees and freedmen. However, the act applied to freedmen and refugees, a formerly race-neutral category, not blacks, writ large. And because not all blacks in the United States were former slaves, this is correct. Not all blacks in the United States were former slaves. Freeman was a descendantly under inclusive proxy for race. I'm just reading this here now, and I'm going to continue to some of the juicier stuff. But I do recommend everyone reads this to really truly understand Clarence Thomas's reasoning and disagreement between with Sotomayor. Adding to the text, some people would say, imposing modern situations, circumstances. Some people call it living constitution. I'm going to get to the part where he starts bringing up specifically Miss Jackson's reasoning. Okay. As much as I'm tempted to look at Sotomayor stuff, today I want to go focus strictly on Miss Jackson and Clarence Thomas. I'm already an hour in, so I need to get to Miss Jackson stuff. I'm going to try to keep this within 2 hours, hopefully. Okay, yeah. Let's go to Miss Jackson. This is actually important information that talks about some of the consequences of affirmative action. Um, Even taking the desire to help on its face value, what initially seems like an aid, this is Clarence Thomas continuing, may in reality be a burden, including for the very people it seeks to assist. Take, for example, the college admission policies here. Affirmative action policies do nothing to increase the overall number of black and Hispanics able to access a college education. Rather, those racial policies simply redistribute individuals among institutions of higher learning, placing some into more competitive institutions than they otherwise would have attended. Thomas Sowell, affirmative action around the world. In doing so, those policies sort at least some blacks and Hispanics into environments where they are less likely to succeed academically relative to their peers. The resulting mismatch places many blacks and Hispanics who likely would have excelled in less elite schools in a position where underperformance is all but inevitable because they are less academically prepared than the white and Asian students with whom they must compete. It is self evident why that is so. As someone who So Thomas Sowell is concurring, or Clarence Thomas is concurring. What I just read before is what Thomas Sowell wrote. As anyone who has labored over an algebra textbook has undoubtedly discovered, academic advancement results from hard work and practice, not mere declaration. Simply treating students as though their grades put them at top of their high school classes does nothing to enhance the performance level of those students or otherwise prepare them for competitive college environments. In fact, studies suggest that large racial preferences for black and Hispanic applicants have led to a disproportionately large share of those students receiving mediocre or poor grades once they arrive in competitive collegiate environments. Take science, technology, engineering, and mathematics, STEM fields, for example. Those students who receive a large admission preference are more likely to drop out of STEM fields than similarly situated students who did not receive such preferences. Interesting, and he cites the study for that. These policies may harm even those who succeeded academically. I have long believed that large racial preferences in college admissions stamp blacks and Hispanics with a badge of inferiority. This is 100% correct, which again goes against the 14th and 15th, the 13th and 14th Amendment of eliminating this inferiority complex, this color, race differences not equal. Because really, when you expound on the idea of equal, what you're saying is that the potentiality of each individual is infinite, no matter the skin color or race. Each individual has the potential to reap what they sow and to live within their means, to build what they desire, and the law should not hinder that. Congress shall not hinder that. The states shall not hinder that, because there is no difference. There is no inferiority. Now, does that make the claim that we should have equality of outcome? That's a totally different theory. Inferiority makes the assumption that everyone shall receive equality of opportunity, equality of prosperity, if they choose to live a life of a millionaire if they wanted to, or a billionaire. And the system, the laws, shall not do anything to not respect the will of each individual and their potential endeavors that they want to pursue. Because what they're saying with no inferiority of any race is they're just saying that they're capable. If they're willing and able and have a strong will, there's no reason why they can't do what they want. And we are seeing that living example now coming to fruition, where we see black folks in every aspect of the world, or every aspect of our system today. On the academic side, we had a president that was black, Supreme Court justices, senators, teachers, going outside the government side of things, different industries like medical. We have a lot of black doctors, a lot of great doctors that are black. We have a lot of great doctors, great musicians. Black folks have dominated the NBA for I don't know how long. Black folks have dominated the NFL for a very, very long time. Now, I would say when you look at the differences between what each race, ethnic group, culture, whatever you want to label it as, dominates, some dominate other things more than others. Some are naturally better at some things than others on a general scale. For example, why is it that there's a stereotype? And it's true, these stereotypes are factual, that black folks typically are faster. The African Americans are typically bigger, huskier, muscular, stronger, right? Is it 100% on every single scale? Not true, but generally speaking, it's true. And there's definitely a reason for that, from the basis of slavery, that led black folks to have the privileges of being more superior in those particular areas, while other races and ethnic groups and cultures are inferior. Does that have to do with anything within the system itself? No. That's simply a reflection of different genes, different upbringings, your mother, your father, the history of your family lineage, the food you ate in your youth, how you were raised. So there's always going to be discrepancies. There's always going to be things that you can view as inferior. In reality, just replace the word inferior with it is natural. It is normal. There's nothing abnormal about that. A lot of people today will just say, well, that is an example of inferiority, and we must correct that to make it easier for those that are inferior. Well, the question I would say to that is, why don't we apply that same type of mindset of inferiority in a particular area, academia, doctors, whatever, where you say that we lack a proper representation of black folks or women, for example? Why don't you apply that same type of logic in sports? Why isn't there affirmative action for, let's say, Asians that drastically lack representation in the NFL and definitely in the NBA? How many Asians do you see in the NBA or NFL? Very, very little. Why don't we use the same rationale of, well, they're inferior, so we should lessen and lower the standards to then show more representation and for it to be more diverse? Because it is a meritocracy. And that's truly what it is. Everything's a merit. It's better whenever it's a meritocracy. That is the most equal and just and natural way for people to function within a civilization. Now, again, I'm going to get into Miss Jackson and the dissenters, but I can already tell you they're all going to that if I'm in their shoes, what I would say is, well, we have gaps, we have discrepancies, we have them, a large percentage of them that's incarcerated or below the poverty line, or unemployment rate, or lack of them doing this particular field that's very successful. Yet again, we don't use that same. They're selectively choosing where they want to apply discrimination as the reason for the disparity, and jumping to the conclusion that it has to be because of past issues and past discrimination. Yet, like I've said in my other videos, America has the most black millionaires in the world. It's over 1 million. It's like 1.5 million black Americans. are millionaires. The chances, statistically speaking, of you becoming a millionaire in America is higher, if not the highest, in the world. People risk their lives to come to this nation because of the opportunity. Not only that, people that are not from this land, they come from Colombia, Central America, Mexico, South America, come to this land as illegal aliens, don't even speak the language, don't understand anything about the rights, the Constitution, and they still make a living here, not knowing the language, not having any type of connection here. Maybe they have some family of some sort, but they don't have any. They have to work under the radar of getting paid cash. All right, let's continue here with Miss Soul. Consequently, when blacks and now Hispanics take positions in the highest places of government, industry, or academia, it is an open question whether their skin color played a part of their advancements. The question itself is the stigma, because either racial discrimination did play a role, in which case the person may be deemed otherwise unqualified, or it did not, or did not. In which case, asking the question itself unfairly marks those who would succeed without discrimination. So, there's a lot of people and African Americans that, and even I would ask myself this too: did you genuinely earn and compete to get your degree or enter a college or get a job? Or was it because you were viewed as inferior, less than, less capable, were meeting a quota, or were handicapped? And a lot of black folks would say, I take offense to that, because that challenges my worth, my value, my dignity as an individual that takes pride in my work, that works extremely hard and wants to earn it equally. The question becomes, whenever you compete for something and you're handicapped, did you really win? Are you really winning? When things are leaned in your favor, is that honorable? Should that be honorable? A lot of people, including myself, would say absolutely not. I want to win and achieve things fairly and equally, not in the sense that other people have to work harder than me because I have the support and handicap of being viewed as special needs, inferior. I mean, we do the same thing with special needs individuals, where we give them handicap, we take it easy on them, we're not 100% with them, we treat them less than, because we understand that they're not 100% there, they're not 100% capable, they have a medical issue, medical condition. Why do we use that same type of reasoning with just off of skin tone and black folks in 2023? We don't see that in the NBA. We don't see that in the NFL. We don't see that in the music industry. I mean, how long has black music, hip hop, gangster rap, pop, soul, funk, that's dominated primarily by black artists, these people that become millionaires through music, we've mainstreamed that. So there's a lot of different avenues that black folks dominate and do very well in, naturally so, that they earned that right. They've earned that money. They've earned that title and position through merit. And they are seeing the blessings of that work by becoming millionaires, by making six figures. A lot of them. So, like I said, I read this yesterday. One thing that you're going to see as a counter argument that I'm pretty sure Mr. Clarence Thomas says, and a lot of other Supreme Court justices that said this should end, was there was no time imposed of when or measurement, quantifiable measurement to say, okay, the justification for reverse discrimination, positive discrimination, we understand that's your reasoning. When does it end? When does your rational, logical conclusion end? I think they call it a logical endpoint, which is a great argument. Does this just go infinite and beyond until what? All black people become millionaires? Until we 100% abolish black folks being in the below poverty line? And it's great because it's like even that is a very, very dangerous water to tread, to say we did this to that other people had to suffer. Everyone had to suffer, even though none of the people alive right now were slave owners. And everyone that's alive right now, you can't guarantee they are beneficiaries. They benefited from their ancestors maybe being slave masters. It's such a complex thing, and so much time has moved on because of it, that you can't get a definitive, concrete. The logistics of it is just terrible. This is going to take longer than 2 hours, but you know what? It's worth it. So let's continue here. If you are still listening and watching my video, thank you so much. You got a great attention span, and you're going to go far in your life. There's a lot of people probably gave up on this video 1 minute in or so. So let's continue reading Thomas's stuff, and we'll get to Jackson here soon. Yet, in the face of those problems, it seems increasingly clear that universities are focused on aesthetic solutions unlikely to help deserving members of the minority group. In fact, universities' affirmative action programs are a particularly poor use of such resources. To start, these programs are over-inclusive, providing the same admission bump to a wealthy black applicant given every advantage in life as a black applicant from a poor family with seemingly insurmountable barriers to overcome. And this is an excellent point. So much time has passed. So much millionaires have been made in the black community. So many black businesses have succeeded. Black entrepreneurs, black athletes, black musicians, whatever route they want to take to get financial freedom in this great land of opportunity in America, that black folks don't start in the same place anymore. There is a multitude of different starting points as far as privileges and financial means that they have that's not equal. So the program that was originally intended to help those that are less fortunate, help those that suffered of the past of discrimination, racism that made them poor and unable to get education and yada yada yada, things that justified reverse discrimination, reverse racism, which is affirmative action, some would argue, benefits even more those that naturally would have gotten into that position. If you're a black man and you're raised in $1 million family and you apply to Harvard, you would have made it in either way through merit. And it completely refutes the argument that, oh, it's because of people that are black and are poor and suffer from the long-term consequences and generational discrimination and oppression that we're dealing with as Blackfoots. It just completely refutes that. And it's inconsistent. Because not all Blackfoots come or start or are at the same place. That they were 100 years ago, 150 years ago, 200 years ago, 50 years ago. In doing so, because again, the argument that they say is a poor family have to have more barriers to overcome, which is true. But every white, Asian, whatever skin tone you want to put on it, that's poor has barriers, more barriers to overcome. That is true. Are they impossible barriers? No. There's plenty of people that I know that their story is I was poor, did nothing with my life, gang violence, etc., etc. And hold on. And they use that to their benefit. I mean, gangster rap culture, really, in essence, that's what it is. They told stories and used the fight to get out of the hood, out of the poor areas that they're at, out of the street life. They themselves then made a living on that. One can say them being very poor worked in their favor because it gave them so much hunger and drive to get out of it. And they just chose an avenue. They used their story and they put it into music and art. And people bought into that. They become a millionaire. They get out of the streets. 50 Cent, Jay-Z, Nas, Snoop Dogg, all these rappers that are black, they use that same type of sequence of events. In doing so, the programs may wind up helping the most well-off members of minority races without meaningfully assisting those who struggle with the real hardships. So that refutes the argument for affirmative action, which is to help those that are less than, that happen to be black folks or Hispanics. Simultaneously, the programs risk continuing to ignore the academic underperformance of the purported beneficiaries of racial preferences and the racial stigma that those preferences generate. Rather than performing their academic mission, universities thus may seek only a facade, I'm assuming, or facade. It is sufficient that the class looks right, even if it does not perform right. This is interesting. Again, one common theme you're going to notice here is a trade-off. In other words, you can't have pure meritocratic system and also force diversity in individuals that look right, which is what he's saying here, looks right, when in reality, not all of them earn the right because you sacrifice meritocracy. Finally, it's not even theoretically possible to help a certain racial group without causing harm to members of other racial groups. It's blatantly obvious. You're either equal or you're not equal. If you're not equal and someone gets the great benefit, someone has to get the short end of the stick. That's just how it works. That is the trade-off. Quote, it should be obvious that every racial classification helps in a narrow sense. Some races hurts others. Some races and hurts others. Opinion of Thomas J. Yada yada. And even purportedly benign race-based discrimination has secondary effects on members of other races. The anti-subordination view thus has never guided the court analysis because whether a law relying upon racial taxonomy is benign or malign, and either turns on whose ox is gored or on distinctions found only in the eye of the beholder. Courts were not suited to be the impossible task of determining which racially discriminatory programs are helping which members of which races and whether those benefits outweigh the burden thrust into other racial groups. As the court's opinion today explains, zero-sum nature of college admissions where students compete for a finite number of seats and other schools entering class. Petitioners here represents Asian Americans who allege that at the margins, Asian applicants were denied admissions because of their race. So the people that suffered the most because of this affirmative actions were Asian Americans. Yet Asian Americans can hardly be described as beneficiaries of historical racial advantages. To the contrary, our nation's first immigration ban targeted the Chinese in part based on work resentment of the low wage rates accepted by Chinese workers, the U.S. Commission of Civil Rights. In subsequent years, strong anti-Asian sentiment in the western states led to the adoption of many discriminatory laws at the state and local levels, similar to those aimed at blacks in the South. And segregation in the public facilities, included schools, was quite common until after the Second World War. Civil rights in the South, 21. The issue of citizenship and immigrant status often defined Asian American battles for civil rights and separated them from African American legal battles. Indeed, this court even sanctioned that segregation in the context of schools, no lex. Yada, yada, yada. The court held that a 9-year-old Chinese American girl could be denied entry to a white school because she was a member of the Mongolian or yellow race. Interesting. Also, following the Japanese attack on the U.S. Navy base, Pearl Harbor, Japanese Americans in the American West were evacuated, interned in relocation camps. Yeah, so this is interesting. Japanese Americans in the American West were evacuated and interned in the relocation camps. They were forced to do so because of concerns that Japanese Americans may revolt or be spies because their country was under attack, the U.S. Navy in Pearl Harbor. So over 120,000 were removed to camps beginning in 1942, and the last camp that held Japanese Americans did not close until 1948. That's crazy. Given the history of discrimination against Asian Americans, especially those history with segregated schools, it seems particularly incongruous to suggest that a past history of segregationist policies towards blacks should be remedied at the expense of Asian American college applicants. So basically, he's making the case that Asian Americans Japanese, Chinese have been discriminated against. And he's trying to refute that argument that discrimination in the past justifies reverse discrimination in the moment, in the current. But this problem is not limited to Asian Americans. More broadly, universities' discriminatory policies burden millions of applicants who are not responsible for the racial discrimination that sullied our nation's past. That is why, in the absence of special circumstances, the remedy for de jure segregation or ordinary should not include educational programs for students who were not in school during the period of segregation. Today's 17-year-olds, after all, did not live through the Jim Crow era, which is true. Enact or enforce segregation laws or take any action to oppress or enslave the victims of the past. Whatever their skin color is, today's youth simply are not responsible for the instituting the segregation of the 20th century. He's basically saying that white folks are not responsible for what happened in the 20th century. Our nation should not punish today's youth for the sins of the past. Very simple. And this is the issue with imposing race-based legislation, no matter the intention or motive or justification. Our nation is so diverse, it is too diverse to go back to that. It's not possible. No matter the reasoning. Far from advancing the cause of improved race relations in our nation, affirmative action highlights our racial differences with pernicious effects. In fact, recent history reveals a disturbing pattern. Affirmative action policies appear to have prolonged the asserted need for racial discrimination. Parties in Amansi, these cases report that in the nearly 50 years since BAKKE, Bach, is that how you say it? Baki, racial progress on campuses adopting affirmative action, admissions policies have stagnated, including making no meaningful progress toward a colorblind goal since Gritter. Rather, the legacy of Gritter appears to be even increasing and strident demands for yet another racially oriented solution. You know what's interesting is that the mindset of the white folks during the past, when you really dissect it, is I'm going to discriminate a group of people, a race of people for my benefit, for me benefiting from it, for me succeeding, and I don't care the consequences or the effects of it. Even though it is blatant discrimination, it's justified because I have to survive. I want to make a lot of money. I have to pay rent, whatever it may be. I have to survive. I want a good life. But either way, black folks had to suffer at that particular moment. Right? This is flipping the script. Now, it's not as blatant, but still, it still affects people's futures of going to Harvard and all these different schools. Obviously, it affected Asian Americans that dominate and do very, very well academically speaking. Asians are extremely sharp. They are the wealthiest per capita if you go off of race for the Asian race. And they divorce the least. They're one of the best races as far as performance and money and circulation within the race itself of money. They eat up and they eat up the opportunities in this nation very well. They eat it up, and they eat it up in silence. In other words, they dominate in silence. A lot of different Asians, ethnic groups that do very, very well, especially here in Texas. Racial diversity, but supporting tribalism and racial segregation on other camp on this, and this is really what it is. It's just tribalism. Whenever you impose tribalism over equality, you can't have a nation that function well and live in harmony with each other if everyone resorts to tribalism. Still, the old way of thinking that the 13th and 14th Amendment try to break and desensitize and deprogram and apply a paradigm shift in this nation. That's what tribalism hinders. It's a trade-off. You can't have both. You can't live in a nation as diverse as America and have tribalism and also live in harmony, work together. It's just not possible. The ideal is that we're all a part of the tribe of America. We are all citizens of America, and that takes precedent over our tribe, over the country we descend from. That's really what citizenship is. That really is what devotion to a nation, pledging an allegiance to this nation is. You don't pledge an allegiance to where you came from. If you come from Ireland or Scotland or what the UK area, the Caucasus Mountains, all those lands, German to Russian, all those pilgrims and Italians, Jewish individuals. When you come to America, you came here for opportunity, and you commit and say, this is where I commit, this is where I'm willing to die for, and this is my allegiance. My allegiance is no longer to my country of ancestry. My allegiance is to America. I want to become an American. And when you become an American, this is the Constitution is really your new identity. Which the Constitution is a very flexible, broad philosophy and worldview that America imposes onto you. You shall and should assimilate to the principles and wisdom within the Constitution, and then build from that. And there's a lot of things missing outside the Constitution, but the Constitution is really what, people are always asking, what's my identity? What's the American identity? It's the Constitution. That's a great part, and you build off of that. And the Constitution gives you an immense amount of freedom to build on. It's not limited or restraining at all. It's a very liberating document. That the boundaries are huge. But you must let go of tribalism. Tribalism and the Constitution are in disagreement. You cannot function in the society or experiment that we are living in right now, where you prioritize tribalism over equality, over realizing that all races have the same desires and needs for the most part. Food, happiness, love, meaning in life, wanting to build an empire, build a legacy, innovation, have a family, whatever. Simple things that we all relate with. We're scared of the same things, and we want a lot of the same things. That's what makes the Constitution so brilliant, because it allows people to freely pursue the same things that we all desire. Which is why tribalism just never made sense to me. The sophisticated you have to transcend tribalism, and that's something that I'm going to do a lot of research on, of why some people resort to tribalism more than others. And this is not just in the black community. There's other communities that are very tribalistic still. Um, and I'm not saying that you should absolutely just give up on your own people and just completely be an individual. You can do as you please, of course, but to just be identified by your tribe and allow it to make it to where you can't live in harmony or function in a society as diverse as America, it becomes a problem. Now, the difference between America and a lot of previous countries is we are united on ideas, visions, virtues, characteristics, as far as not physical characteristics, but personal characteristics. Are you hardworking? Are you a man of your word? Do you have integrity, etc., etc.? And then visions, concepts of what freedom is, the definition of freedom, free speech, the right to bear arms, right to express yourself, checks and balances, freedom of the press, freedom of religion. We can all agree that those are necessary things that we all need and have. It's an option for us to choose to consent to these things. The Constitution is a brilliant, beautiful document. It really is. That's why it's lasted as long as it has right now. And it is the oldest document, oldest constitution in the world, if I'm correct. So let's continue here, because we're almost hitting 2 hours. So I can go on. I love talking about this stuff. So, tribalism and racial segregation on their campuses, including through minority only, yada, yada, yada. I want to get to the point. Actually, let me get this is pretty important. In fact, a recent study considering 73 schools found that 43% of colleges offered segregated housing to students of different races. 46% offer segregated orientation programs, and 72 sponsor segregated graduation ceremonies. Neo-segregation at Yale. This is just terrible. This is going back. Like I said, our nation. If we teach the youth that you should relate with people primarily off of how they look, and if they look like you, to where you should have the assumption that you should prioritize your tribe. Your tribe is America. Your tribe is you are an American. We are Americans. You can even be a tribe of your state. Georgians, Missourians, New Yorkans, Californians, Texans, Mississippians, whatever. Overall, we are all Americans under the Constitution. So this whole segregation stuff just goes to show that the consequence, the unintended consequence of affirmative action, and the great emphasis of obsessing and prioritizing tribalism and doing microanalysis of tribalism. The diversity that we have in our nation is our greatest strength, but also it is our greatest weakness. Anything free speech, the Second Amendment, really anything that's meant for good can be weaponized and used and flipped on itself for bad. It really can, and we're seeing it play out right now with the diversity that we have in this nation. There's no need for this. I can understand, separation of male and female as far as bathrooms and sports, but as far as academics, Male and female can live in harmony. As far as jobs, male and female can live in harmony. But races, there is no need. There is when you see this segregation stuff, what you're implying without even trying to imply that is inferiority, different privileges, possibly guilt within a certain race. This hyper obsession with being defined by your race and the past and where you start. You know, it's interesting. It never makes sense to me because data completely goes against this. I think on my other video, I talk about a NASDAQ study that says that from first generation to second generation, there's a 70% chance that the wealth built in the first generation is wasted in the second generation. And then from second generation to third generation, whatever is built in the second generation, the third generation, there's a 90% chance the third generation wastes it, doesn't build on it, does not sustain it. There's no guarantee that simply just because you inherit money and wealth, that's going to continue and sustain. Statistics show differently. So the hyper obsession of where you start and that where you start is a great something that is a great definer of where you're going to go and the likelihood of you succeeding. Whatever the statistics and data is, who cares? Because there is plenty of people that can do it. If you are willing to do it, if there is a will, then you can do it. You can achieve it. Especially now, where there is a multitude of avenues with the internet being so huge. Ways of making money, some that people disagree with. I'm not going to go into details. But you can make a lot of money with the internet and social media while not needing to do a lot of labor, physical labor of being outside, lifting stuff, risking your life like our ancestors had to do, factory jobs and whatnot. Things have changed. Opportunities are more plentiful now than before. More conveniences, more luxuries. Don't let where you start define you. No, don't let the past define you. These people that impose that through data and social studies and social theories and all these experts and yada yada yada. It's so easy to just look at data and feel sorry for yourself. But the reality is that there's always going to be people that are just not going to want to succeed or do well in their life. Every single population or race has that. Some people just don't desire to be millionaires. Some people don't desire to make six figures. Some people have different priorities in their life, whatever it may be. Some people like the simple life. So just to do this broad metric that, these guys are below poverty line. Some people genuinely, I've met people that are millionaires, six-figure earners, and are miserable and unhappy and hate their life. I've met people that make $50K, below 30, 40K, live in the sticks, middle of nowhere, Mississippi, these areas that are very cheap and affordable, middle of nowhere, and they are happy and content and doing just fine with the simple life. Don't relate or like the city folks. And this is of all races, white, black, etc. So these analysis of below poverty line, that we have to do something about it doesn't make sense because you're assuming that each individual just hates their life. You're also assuming that just because you make a lot of money that you're going to be happy and that's the meaning of your life, to make a lot of money. It's not. People aren't that simple. It's a multi-variable thing that people have different desires and want to focus on different things. There's plenty of people that they want to just preach the gospel of Jesus Christ and travel the world and live below poverty line and live off of donations. and they are not a materialistic individual that spends frivolously. They're very frugal, and they appreciate the little things. There's a lot of people like that. All right, where are we here? Meanwhile, these discriminatory policies risk creating new prejudices and allowing old ones to fester. I previously observed there can be no doubt that discriminatory affirmative action policies injure white and Asian applicants who are denied admissions because of their race. Petitioner here clearly demonstrates this fact. Moreover, no social science has disproved this notion that is discrimination. Yada 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 yada. So, I think I skipped this area, but I read yesterday of what University of North Carolina, was it UNC, and Harvard were doing, of how they screen and filter out their applicants. And race is one of the things they use to decide if the applicant should be allowed in. And sometimes, obviously, academically speaking, they may not be as smart as, let's say, an Asian applicant, and the Asian applicant, academically speaking, will meet everything just as good as the black applicant, if or better. And the black applicant can just because of the race, they'll make exceptions and will choose them simply because of that, of wanting to appear diverse. And I read yesterday. Oh, I gotta find that, because they were using the justification and trying to this is the Harvard and University of North Carolina. I gotta find that. This is a huge document, 237 pages. I don't think I'm gonna be able to find that. They were saying that they wanted to make sure that that the representation of minorities stayed consistent and balanced within each class. And I'm not quoting it correctly, so I'm not going to speak on it because I'm not quoting it correctly. I wish I would have found it before I scrolled all the way down here, but maybe I can go back there after reading Thomas's concurring opinion, because I want to break down why colleges were saying their reasoning was for how they screen out candidates and how affirmative action is applied through the screening process. So Justice Jackson has a different view. Rather than focusing on individuals as individuals, her dissent focuses on the historical subjugation of black Americans, invoking statistical racial gaps to argue in favor of categorizing individuals by their race. As she sees things, we are all inexorably trapped in the fundamentally racist society, with the original sin of slavery and the historical subjugation of black Americans still determining our lives today. So we're going to get into Jackson's opinion here very, very soon. The panacea she consoles is unquestionably accede to the view of elite experts, yeah, and relocate society's riches by racial means as necessary to level the playing field, all as judged by racial metrics. I strongly disagree. First, as stated above, any statistical gaps between the average wealth of black and white Americans is constitutionally irrelevant. This is so important. Because the original question is affirmative action constitutionally protected? Is it a constitutional right? Which is simply positive discrimination, whatever you want to call it, reverse racism. That's all it is. It's very simple. It's not that complicated. Judging an individual by race, using race as something to either impose restrictions on or give privilege to or judge, simply judgment of race. That's really all it is. So, as we just read for the last hour or so, the 13th, 14th Amendment makes clear of equal, the same, no inferiority, nowhere, all equal. So it's very hard to make the case in support of racial metrics. I, of course, agree that our society is not and has never been colorblind. People discriminate against one another for a whole host of reasons. It's absolutely correct. People discriminate against their own people all the time. So the notion that that today it is strictly a black versus white thing is false. To claim that blacks cannot be against their own kind and that blacks don't oppress or kill other blacks is a lie. Statistically speaking, blacks murder their own kind higher than any other race. I think it's 70% last time for 2019, year 2019. And other races do the same thing. It's not just blacks. Most people kill their own, for the most part, kill their own race. White, black, etc. And even these terms, man, they're so vague. Because white that's a huge, broad definition to bring together different countries that were always at war with one another. The Europeans, for example, the people in the Caucasus Mountains, they were at war for a long time, enslaving one another, killing each other, fighting for land, colonizing land. Different empires, collapsing empires, the Roman Empire, for example. There's a deep history of this stuff. So this whole thing of committing to your country, that stuff changes. Nations collapse, nations get subjugated, nations get taken over. So this modern social construct of today that we have, which is just a general agreement to say that in this particular timeline, because this land is still present, and my ancestors came from this land in the last 100, 200 years, then that's where I'm from. Without realizing, well, where were your ancestors from? Where's your lineage connect you whenever you're from 500 years ago compared to today? 1,000 years ago? What about 2,000 years ago? We don't know. So this whole allegiance to your skin tone, allegiance to your country of Africa or Europe, it makes no sense. Because humans for thousands of years have moved around and killed and the Black Plague and died. There's so much to this that it's just way too complex and unnecessary for people to obsess over tribalism. It makes no sense to me. And even these broad categories of white versus black. You go to Africa, a lot of countries in Africa don't get along, enslave one another, go to war with one another. Now, absolutely, there are white colonies, white countries that are like the French and the English Empire that have done terrible things to African Americans, or Africans in their African country. The Spaniards and the Spanish Empire. All right, so let me see here. In the view of the Constitution, quote, in the eye of the law, there is in this country no superior, dominant, ruling class of citizen. There is no caste here. Our Constitution is colorblind. As he explained in the 14th, 13th Amendment, and in the words implied in the second founding, where they imposed the colorblindness interpreted in the founding document. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surrounding or of his color when his civil rights are guaranteed by a supreme law of the land are involved. And he goes over the 14th Amendment and just hammers that point. And then Jackson will replace the second founding vision with an organizing principle based on race. In fact, on her view, almost all of her life outcomes may be unhesitantly ascribed to race. This is so, she writes, because of statistical disparities among different racial groups. Even if some whites have lower household net worth than some blacks, what matters to Justice Jackson is that the average white household has more wealth than the average black household. And this is a terrible argument to say that the Constitution all of a sudden is a document that should be used to economically balance and use discrimination and racism to justify errors and discrimination of the past. The thing that Jackson fails to see is that discrimination is what caused the issues of the past. The common theme here, the common problem is discrimination, inferiority, tribalism, being defined by race, even if it's for the good or for the bad. It is a destructive, old way of thinking that we must move past. While Justice Jackson, in my opinion, means well to say that using this argument of the average white household wealth, for one, the average income, let's look up what is the average income. What is the average household income by race in America? Okay. The highest is Asians, 93,390. The lowest is blacks or African Americans, 48,871. 70,448, 2014 and 2016. To just conclude, to make the great leap that the reason why there is a disparity and disproportional difference between this number and this number, that it is strictly because of racism, because of Jim Crow, because of slavery, is a very overly generalized assumption that is way too simplistic and ignores a lot of different variables, and it's just too broad. It's way too broad. How can Miss Jackson explain the 93,390 and the Asian Americans? Asians didn't own slaves in America. Asians didn't own black slaves in America. Asians didn't found this nation. Asians are a minority in this nation, more of a minority than African Americans. This lore is not and has never been true. Even in the segregated South where I grew up, individuals were not the sum of their skin color. Then, as now, not all disparities are based on race. Not all people are racist. Not all differences between individuals are attributable to race. Put simply, the fate of abstract categories of wealth statistics is not the same as the fate of given set of flesh and blood human beings. Worse still, Justice Jackson uses her broad observation about statistical relationships between race and select measures of health, wealth, and well-being to label all blacks as victims. Her desire to do so is unfathomable to me. I cannot deny the great accomplishments of black Americans, including those who succeeded despite long odds. Nor do Justice Jackson statistics regarding a correlation between levels of health, wealth, and well-being between selected racial groups prove anything. Of course, none of those statistics are capable of drawing a direct causal link between race, rather those socioeconomic statuses or any other factor in individual outcomes. So Justice Jackson supplies the link herself: the legacy of slavery and the nature of inherited wealth. This, she claims, locks blacks into a seemingly perpetual inferior caste. Such a view is irrational. It is irrational because, for one, just simply giving people money does not guarantee that they're going to sustain and multiply that money. So absolutely, it's irrational. Why is it that we see people win the Powerball and they end up broke again? Such a view is irrational and is an insult to individual achievements and cancerous to the young mind seeking to push through the barriers, which is necessary. We need individuals and young minds to push through barriers, go through hardships. Me personally, I'm a black American. I've been through some crazy hardships. I have restarted and been on ground zero multiple times. I have effed up and fallen on my ground through my own mistakes multiple times. I have been completely lost and unsure of where I'm going and how I'm going to make it and making it meet multiple times. That being said, those things define me and put me to where I'm at right now. Forced me to go beyond my capabilities in that particular moment. Forced me, put a fire on my ass to make something of myself and overcome the adversity at hand. Everyone needs that. Everyone needs challenge. Everyone needs adversity. Everyone needs barriers to overcome. That is part of your self-development as a human. I would argue that to the degree of the amount of adversity that you have and overcome is the degree of wealth that you will get in return because you earned that right. You have built wisdom of overcoming those barriers and hurdles. You have the wherewithal and will to continue that because you now have the power of overcoming adversity. A lot of people are terrible and are not capable of, they cave into pressure. They cave into adversity. They can't overcome it. Why do you think Michael Jordan and Kobe Bryant were the most dominant forces in the NBA, made history? Michael Jordan, perfect example. The guy is a billionaire with a B. He is a billionaire, made a brand of himself. He exudes excellence. He's an example of that. When you see his mindset of what he overcame, he didn't inherit nothing. He worked his ass off to become who he was. The icon, the legend that people will be talking about for generations. He did that here in America. I'm not saying everyone can be like Michael Jordan, but he's an example of the benefits that you get when you overcome adversity and how strong mentally you can become in this country when you truly self-actualize yourself. Right? When you really self-actualize and maximize your potential and get into the mindset of self-government and personal responsibility, accountability, you can become king within your own right. You can become king of your domain, become king of certain industries and areas and certain cities and whatever it may be. You want to be a king in this particular business, in this particular city, whatever it may be. But you need barriers to overcome. I am grateful. You must reframe. And a lot of this stuff has to do with mindsets of each individual. You must reframe what barriers mean to you as an individual. Barriers should no longer mean oppression. Barriers should no longer mean racism. Should not mean that the system's out to get me and the system's working against me. No, it shouldn't mean that. If you redefine and reinterpret what barriers, adversity, hardships mean, then you can truly move past them and become a better, stronger person. You don't need the government, the daddy government, to make a living, to make a business and industry off of your grievances and lack of your potential and maximizing on your abilities in this life that you have, in this nation that you have, in this particular timeline. Nobody is holding you back more than you and what you tell yourself. This is the last resort when the government has to resort to truly assuming that the only way that black people can move up is for us to conclude that they are inferior. What this implies, without Justice Jackson realizing it, is that black people are inferior and incapable to do it alone, themselves. That they need the government to lift them up, and we must use reverse racism. And the justification is simply history. They just use history to justify it. That's it. But really, the biggest thing that should concern you, if you're a black person listening to this, is they're implying that you are incapable. They're already imposing the assumption that you are not capable, that you can't do it alone, that you are the inferior race. Crazy how that all circles around again. No matter the intent, it's the same theme that was imposed to black folks and told to black folks during the 20th century, during the slave era, during the Jim Crow, etc., etc. Why do black folks inherit and continue what white folks imposed and conditioned you to believe? Why do we continue that? I'm going to make another video looking into what genuinely was told to black folks and slaves. Everything implied inferiority. Everything implied they are unable. Everything implied that they needed, that they can only survive and do well with the slave master. Well, I don't see any difference between a white slave master and the government being the slave master, or a party being the slave master. Doing it for your own good. It's a huge slap in your face if you're a black guy listening to this, black woman listening to this. I'm repulsed. I'm disgusted. I'm also motivated because I want to prove Justice Jackson wrong. I want to debunk, refute this narrative and assumption that is implicit, it is implied in in the whole argument that she's fighting for. Accordingly, Justice Jackson's race-infused worldview fell flat at each step. Individuals are the sum of their unique experiences, challenges, accomplishments. What matters is not the barriers they face, but how they choose to confront them. And their race is not to blame for everything, good or bad, that happens in their life. It's natural. It's a thing we have to deal with. A contrary, myopic worldview based on individual skin color is a total exclusion of their personal choices, is nothing short of racial determinism. And this is a good way of putting it, Mr. Thomas. Racial determinism, which really is racism. You are determining that just simply because you're black, that you are determined to not succeed. You are predetermined, and it's being told by Jackson that, oh, we have to lift you up. Poor little baby. That you're handicapped. That you're almost like a special needs individual. That's what they're implying. Justice Jackson then builds from her faulty premise to call for action, arguing that courts should defer to experts and allow institutions to discriminate. I hate this, bro. This whole thing of like resorting to experts for everything in every situation. Experts get things wrong every single time. Whenever you make a living on trying to address grievances, why is it in the benefit of those making a living of trying to solve, quote unquote, solve a grievance? What is in their benefit to actually resolving the grievance when if they continue to sustain and maybe fix or appear to fix the grievance or problem, they make more money not resolving the grievance, the social grievance, the disparity. The government does the same thing. Nobody wants to fire themselves trying to resolve a cultural, social issue, because then they can't make a living off of that. What else are they going to get into? This is the stuff why I'm very skeptical of these social studies and ethnic studies and people that are obsessive of discrepancies and disparities. Make no mistake, her dissent is not a vanguard of the innocent and helpless. It is instead a call to empower privileged elites who will tell us what is required to level the playing field amongst the caste and classifications that they alone have divine. Explain the. Then, after siloing us all into racial castes and pitting those castes against each other, the dissent somehow believes that we will be able to, at some undefined point, to march forward together. This is crazy to me. At what point is it enough to justify reverse racism? Positive discrimination. What the hell is that? Man, if I was a slave, imagine telling that to a slave master. Hey, it's just positive discrimination. You're just doing what's best for your family. It's justified. You're just trying to make ends meet. You're just trying to make a living as a white man in America. It's perfectly fine to discriminate and be blatantly racist to the black man and enslave the black man. It's positive discrimination. It's positive for who? It's positive for you, the white man. So because it's positive for you, the white man, we should just continue it, right? Doesn't matter about the black man. Makes no sense. The thing is that we're not going to march together. There is no together. Together implies equal. Together implies that everyone consented to this. All other races consented to this. If you have to bring others down to bring yourself up, that's not together. They didn't consent to that. Asian Americans didn't consent to this. White Americans did not consent to this. To be put down, to get the short end of the stick. They didn't consent to it. And here you go. And this is you're gonna see this a lot. Utopian vision. This is the delusion of some people that they resort to these experts to tell them once we resolve this, everything will be great. We'll march forward together. And they give these vague studies, the overgeneralizations, and this virtue signaling of trying to appear like we're trying to help and assist you. They make a living on selling false hope, on selling false solution, and on sounding good on things at face value. But whenever you apply it and break down the details and the multivariable analysis, a lot of it just gets debunked and it's false. And it's just inaccurate. Social movements that invoke these sorts of rallying cries historically have ended disastrously. This is like a lot of people, the Great Leap Forward, the communist stuff, Hitler, all this whole thing of subjugating yourself, subjugating others, bringing down others. A lot of the time, these people, it doesn't end well, historically speaking. It's a great point by Clarence Thomas. Unsurprisingly, this tried and failed system defies both law and reason. Start with the obvious. If social reorganization is the same of equality may be justified by mere fact of statistical disparities among racial groups, then that reorganization must continue until these disparities are fully eliminated. Regardless of the reason for the disparities and the cost of their elimination, if blacks fail a test at higher rates than their white counterparts, regardless of whether the reason for the disparity was anything at all to do with race, the only solution will be race-focused measures. This is it, like race-focused measures to ignore the reality of their incapability, of not being capable, not meeting the merits necessary of passing the test. If they fail more, if they have higher rates of less literacy, it can't be the culture, it can't be the family, it can't be lacking, a good household, it can't be nothing like that. No, it's not that. It is because of what happened in the past, the slave era, Jim Crow, etc., etc. Has to be racial. Has to be racial. Victimhood. Constantly obsessing and using excuses of victim. You are not a victim, black people. We are not victims. No longer are we victims. No longer will we be told that we need someone else help. We need the system's help. We need the government's help. That we need some politicians' help. Some parties' help. I don't give a damn about Democrat or Republican Party. None of them do you need help of overcoming your adversities and your process of self-actualizing and becoming a mature, wise, productive citizen in America. If you need evidence to support this claim, all you got to do is just look at all the successful black people in this nation. That's all you got to do. Look at Larry Elder, Thomas Sowell, all these different black folks that went in avenues that 200 years ago they weren't able to go into. Now we see them everywhere. We see black folks everywhere. News, media, entertainment, every avenue, and they're making millions on this stuff. They're competing. They're putting themselves out there. They are now fully immersed in the pursuit of happiness and the opportunities within this great land, this great country, this young country. In fact, there would seem to be no logical limit to what the government may do to level the racial playing field. Outright wealth transfer, quota systems, racial preferences would all seem permissible. In such a system, it would not matter how much innocents suffer race-based injuries. All would matter in reaching the race-based goal. Worse, the classification that Justice Jackson draws are themselves race-based stereotypes. Correct. She focuses on two hypothetical applicants, John and James, competing for admissions to UNC. John is white, 7th generation legacy of the school, while James is black and would be the first in his family to attend UNC. Justice Jackson argues that the race-conscious admission programs are necessary to adequately compare the two applicants. As an initial matter, it is not clear why James' race is the only factor that would encourage UNC to admit him. His status as first-generation college applicant seems to be contextualizing his application. Correct. The information of simply being a first-generation into UNC within the family, that can be implied and communicated. But setting that aside, why is it that John should be judged based on the action of his great-great-grandparents? 100% true. There are multitude of people that the next generation is full of degenerate losers of children. I know plenty of families like this. I know plenty of celebrities like this. Michael Jordan is a great generation within the Jordan family. Do you see his kids guaranteed to be the next Michael Jordan, excellent top tier basketball player? No. It's the same thing with musicians, the same way with actors, any field. Simply because your great-great-grandparents got into something, did something, achieved something, does not guarantee that you have the gene that is passed down to the next generation, and then automatically you're going to do the same thing, if not better, and act exactly the same. That makes no sense. There's no guarantee that from generation 1 to generation 2 that they're going to be better, if not greater. They may do a different avenue. They may have different pursuits, different things that fulfill them. Each individual is an individual and should be treated as an individual. This is the flaw of tribalism, that it implies and assumes and affirms that the generation to the next generation ought to be the same, without the understanding that from generation to generation, there's a lot of variables that go into it. So many variables. Like, for example, I'm fascinated by folks that start from nothing and have so much drive and ambition. And they're the first to make something of themselves and their family. Maybe they're the first person in the family to get a college degree. Maybe they're the first person in their family to be a millionaire. Maybe they're the first person in their family to start their own business. Whatever it may be. Where they are the first in their family to do something, to make great achievements. Yet there is nothing in the previous generation that they inherited or piggybacked off of or were privileged off of. There's nothing. There's plenty of stories of people that they were raised and poor, nothing, had nothing, raised in a broken family, maybe went to prison, and they still had successes. That's a phenomenon that must be understood. To just make this mass generalization that, oh, if we give them this, then it's guaranteed they're going to do that, and it's guaranteed that if generation one has the blessing of going to the school and yada yada yada, then they're guaranteed and they're entitled to then get into the UNC again. I don't understand. It makes no sense to just, these mass generalizations are naive. They really are generally naive. And what would Justin Jackson say John would be deemed him not as worthy of admission? Some statistically significant number of white people had advantages in college admissions just 7 generations ago, and you have inherited their incurable sin. Nor should we accept that John or James represents all members of the respective races. Correct. Every race is different. Jews were not considered white folks by some people in America. Irish people were considered slaves to some degree. There was a cattle of... I got a book that talks about how white folks were slaves in this nation. It's just not as black and white like that. Now, some people absolutely in the South were blatant about the white superiority and yada, yada, yada. But even those people in the South didn't like Jews. And didn't consider Jews white. And didn't consider mixed races as white. Had weird definitions. It's odd. It's just a terrible way to view the world. From the victim of it to the perpetrator of it. And anyone that wants to weaponize it for their benefit or for destruction. Doesn't matter. All racial groups are heterogeneous. I want to make sure I understand what that means. Heterogeneous, I'm pretty sure, means that they're just all different. Yeah. Diverse. They're varied. Yeah, that's what it means. Which means that, like for example, my father and mother are both from the same country. Right? They're both Dominican Republic. I have some things that are kind of like my mother. I have some things personality-wise, looks-wise. I have some things that are kind of like my father, looks-wise, personality-wise. But I have a lot of things that I have nothing in common with them. I'm my own individual person. My upbringing is different from them. My circumstances are different from them. My surroundings are different from them. They move me around. The culture I was raised is different from them. The state is different from different country. It's all those complexities and variables completely change things from one generation to the next. I had different luxuries as them, different conveniences, different problems. Just different. Different timeline, different era, different music, different ways of speaking, different styles. The internet wasn't big in their timeline. There was no internet. Smartphones, calling people. I mean, it's just a different timeline. All of those things influence and change generation to generation. All right. Nor shall we accept that John and James, and blacks are no exception, encompassing northerners and southerners, rich and poor, recent immigrants and descendants of slaves. Thomas So, noting that the great success of West Indian immigrants to the United States, disproportionate among blacks more broadly, seriously undermines the proportion that color is a fatal handicap in the American economy. Eschewing the complexity that comes with individuality. It's extremely complex. May make for an uncomplicated narrative by lumping people together and judging them based on some inherited or ancestral traits is nothing but stereotyping. That's very, yeah, like the compartmentalizing people is just terrible because it's inaccurate. It's hard to just make these compartments. Like you can make like macro compartments when it comes to like Americans versus Chinese and American, the country itself versus the Chinese country and maybe state by state. But compartmentalizing to compare people by race is very complex and hard to come to definitive conclusions because there's so many variables when you get to that scale, that micro scale. To further illustrate, like for example, even Asians, like we've compartmentalized Asians, but even Asians has different sub ethnic groups. I'm probably saying it wrong, but you get what I'm saying. Sub Asian individuals from Koreans, right, to the Pacific Islanders, to Japanese, to Chinese, right? There's the Asian descent of people. It's just so different. There's so many different countries that are in the umbrella of Asian. To further illustrate, let's expand the applicants' pool beyond John and James. Consider Jack. This is Thomas Sowell continuing. Consider Jack a black applicant and the son of a multimillionaire industrialist. So they're both black. One is a multimillionaire industrialist. In a world of race-based preferences, James's seat could very well go well to Jack rather than John. Both are black after all. And what about members of the numerous other racial and ethnic groups in our nation? What about Anne, the child of a Chinese immigrant? Jacob, grandchild of Holocaust survivors who escaped to this nation with nothing and faced with discrimination upon arrival? Or Thomas, the grandchild of an Irish immigrant escaping famine? While articulating her black and white world literally, Justice Jackson ignores the experiences of other immigrant groups like Asian and white communities that have faced historic barriers. Correct. Now, to play devil's advocate here, is it to the degree that African Americans experience in this nation? No. It's not to that degree. Is it as recent and in a mass scale as far as the numbers? No. There's Asians are the minority in comparison to African Americans. That being said, as time has passed, the effects of it has dwindled, of slavery and the Jim Crow. As time has passed, the effects of it dwindles. So it's a matter of time before we start to see and the proper prioritization of what things need to be fixed within the black people, the black community. I'm going to be blunt with you. We got a broken, bad culture. We need to fix the black culture. It wasn't like this 100 years ago. It wasn't like this 80 years ago. Black on black crime wasn't nothing like it is now. Blacks poisoning each other with drugs wasn't like this 80 years ago, 100 years ago. That's a variable that has to be put into account that Jackson just ignores. Justice Jackson. Through Justice Jackson seems to think that her race-based theory can somehow benefit everyone. It is an immutable fact that every time the government uses racial criteria to bring the races together, someone gets excluded and the person excluded suffers an injury solely because of his or her race. Correct. There's no such thing as a balanced, wholehearted, everyone's kumbaya, everything's equal, but we got to handicap a race of people because of past discrimination. Someone has to lose for someone else to gain. And that type of preferential race-based judgment, race-based solution under the when you use the law to apply that. Indeed, Justice Jackson seems to have no reason, no explanation at all for the people who will shoulder that burden. Correct. How, for example, would Justice Jackson explain the need for race-based preferences to the Chinese student who has worked hard his whole life, only to be denied college admission in part because of his skin color? In other words, we're telling Asian Chinese student, even though you worked your whole life, you might be denied, might not be considered because we have to use reverse discrimination and we prioritize black folks because of previous discrimination in the past, even though I understand Chinese people were also discriminated against in this nation. See how it just creates a very complex, uncomfortable situation? For one, the Chinese student didn't consent to this setup. And it completely goes against the founding fathers' vision of the pursuit of happiness, of equal opportunity. If such a burden would seem difficult to impose on a bright-eyed young person, that's because it should be. History has taught us that to arbor theories that call for elites to pick racial winners and losers as the name of sociological experimentation. It's just terrible. Titles like this are just word jargons and these elite people that are so the intelligentsia, right? Intelligentsia is what they are. These elite people that they like to hear themselves talk and use these big words and make it seem like they're gods and know everything and all this crap. I mean, I get it. It's a job they choose, but it's repulsive because a lot of them do more harm than good. A lot of theories, a lot of ideals that are just detached from reality because they themselves don't really understand on the ground what's going on. And they use the same broad generalizations that you hear Justice Jackson using, ignoring a multitude of different variables because they want to affirm and continue and prioritize a narrative of that white people are to blame for everything, that black folks are a victim, and black folks should feel sorry for themselves. And they are implicitly saying within these good intentions that black people are inferior. Nor is it clear what another few generations of race-conscious college admissions may be expected to accomplish. Even today, affirmative action programs that offer an admission boost to black and Hispanic students discriminate against those who identify themselves as members of other races that do not receive such preferential treatment. Must others in the future make sacrifices to re-level the playing field for this new phase of racial subordination? Again, this is why do we keep bringing the past to destroy the current, to affect the current? And I'm going to give you guys just a food for thought because I may say that, but America has paid reparations, dollar amount reparations, to a lot of different races in this country. And it's a very strong point of those in the black community, Democrat blacks, whatever, they genuinely think that reparations is the answer. And why is it that we gave reparations to other communities, but we're not giving reparations to African Americans? This is a very uncomfortable truth for a lot of folks in America. But we've given tens of thousands of dollars, billions of dollars to other countries. And also, let me see if I can read some of this. Let me pull this up. Let me pull this up. Let me pull this up here. I have to. Give me a sec here. See if I can email this to myself or something. Ready? Yeah. Ooh wee! 3 hours. But I'm enjoying this discussion. I am enjoying it. Hopefully, I don't know if anyone's even going to listen to this, but I'm learning as I discuss this. So this is very controversial here. This is the reparation, the historical timeline of reparation payments made from 1773 to 2023 by the United States of America. States, cities, religious institutions, university, corporations, and community. And this talks about different cases and different movements, and it's very interesting when you look at the history of this nation. That being said, so 1863, over 4 years in July, mobs of white New Yorkers terrorized black people by roaming the streets of City Hall and the Jericho Park of the 40th Street, setting fire to buildings and killing people. The overall death toll is estimated to be between over 100 and 1,000. Immediately after the riots, the white merchants of New York report blah 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 combined forces to raise money to care for the injured, repair and damaged property, and support the legal and employment needs of the communities of black people. The shopkeepers raised over $400,000, equivalent to $825,000 in 2021. So, anyone wants to look at this, maybe I can post a link here, but this is the link on the top right. Hopefully you can see that. See if I can zoom in. No, I can't zoom into that. But we have, because there's a huge push demand for black folks for reparation. And that's a separate argument. But America has done a lot of things under the name of correcting issues, wrongs, and usually it's in funds to certain cities and groups and religious groups, yada yada yada. And I would also say that affirmative action is a form of reparations. It is a form of reparations through employment, through means of education, where again we're trying to correct the past wounds and the past sins. That's the objective, and the government is attempting to do so. That's why they justify the affirmative action, the positive discrimination, as they put it. So let's continue here. University's recent experiments confirms that efficacy of colorblind rule. To start, universities prohibited from engaging in racial discrimination by state law continue to enroll racially diverse classes by race-neutral means. For example, the University of California purportedly recently admitted its most diverse undergraduate class ever, despite California's ban on racial preferences. This is talking about Michigan. He's just hammering that point that we don't need race-based preferences. One can say race-based quotas to meet the needs of demanding diversity of African Americans in the education college system. Race-neutral policies may thus achieve the same benefits of racial harmony and equality without any of the burdens and strife generated by affirmative actions. In fact, meritocratic systems have long refuted bigoted misperceptions of what black students can accomplish. I have always viewed higher education purposes as important knowledge and skills to students rather than communal rubber stamped credentialing process. And I continue to strongly believe and have never doubted that blacks can achieve in every avenue of American life without the meddling of the university administrators. Meritocratic systems with objective grading scales are critical to that belief. Such scales have always been a great equalizer, offering a metric to achievement that bigotry could not alter. Racial preferences take away this benefit, eliminating the very metric by which those who have the most to prove can clearly demonstrate their accomplishments, both to themselves and to others. School successes, like students' grades, also provide objective proof. And this is talking about the historically black colleges and universities do not have a large amount of racial diversity, but they demonstrate a marked ability to improve the lives of their students. To this day, they have proved to be extremely effective in educating black students, particularly in STEM, where HBCUs represent 7 of the top 8 institutions that graduates in the highest number of black undergraduate students who go to earn science and engineering doctorates. HBCUs have produced 40% of all black engineers. Presidential proclamation, and they have account for 80% of black judges, 50% of black doctors, and 50% of black lawyers. This is at HBCUs, historically black colleges and universities that are primarily black. In fact, through Xavier University and HBCU, with only a small percentage of white students, has had better successes in helping its low-income students move into the middle class than Harvard has. See Hammond 14, brief, in each of these top 10. So the top 10 HBCUs have a success rate above the national average. Why then would this court need to allow other universities to racially discriminate? This is well said. The HBCUs account for a lot of different benefits of black doctors and higher educations and engineers and outperform Harvard. It's a very strong point. The hard work of the HBCUs and their students demonstrate that black schools can function as the center of a symbol of black communities and provide examples of independent black leadership, success, and achievement. Such black achievement in racially isolated environments in neither new nor isolated to higher education. Continue with Clarence Thomas. The great failure of this country was slavery and its progeny. I'm not saying that right. And the tragic failure of this court was its misinterpretation of the Reconstruction Amendments. As Justin Harlan predicted in Plessy, we should not repeat this mistake merely because we think as our predecessors thought, and that present arrangements are superior to the Constitution. The court's opinion rightly makes clear that Grutter is full, all intents and purposes overruled, and it sees the university's admission policies for what they are: rudderless, race-based preferences designed to ensure a particular racial mix in their entering classes. Those policies fly in face of our colorblind Constitution and our nation's equality ideals. While I am painfully aware of the social and economic ravages which have befallen my race, this is Mr. Thomas, Supreme Court Justice Thomas, which have befallen my race and all who have suffered discrimination, I hold out enduring hope that this country will live up to its principles so clearly enunciated in the Declaration of Independence and the Constitution of the United States that all men are created equal, are equal citizens, and must be treated equally before the law. Where is the... There was something that he talked about that I want to bring up. Where was that? I took a picture of it yesterday. Page 95, I think it was. I guess I skipped it. Let me go to page 95. Yeah, this is an excellent point that Thomas made. And this talked about our nation should not punish today's youth for the sins of the past. Let me see, where is it? Oh, I think I skipped over it. Page 95, was it? Yeah. What then is the end point? Hold on, no, that's not it. He made a very interesting point talking about the concept of race and race being a social construct. It was a great point. Individuals, other wish for their successes may resent members, yada, yada, yada. What then would be the end point of these affirmative action policies? No racial harmony, integration, or equality under the law. Rather, these policies appear to be leading to the world in which everyone is defined by their skin color, demand ever increasing entitlements and preferences, and on that basis, which is correct. Entitlements strictly because of skin tone. And this victim Olympics. That's what it creates. A victim Olympics of whoever is the most oppressed, then they get the most out of it. They deserve, they're entitled to correct things of the past, and that we should give them free things, and again, this implies so much demoralizing, destructive things into the individual, into the mind of the person that buys into this stuff. If you truly believe that you are entitled and that you are a victim and defined by your past, then you're going to assume that and not even attempt to overcome your objectives. You're disempowered at that point. You have been successively disempowered. This is not empowering. This is disempowering. This is demoralizing. And this is the point. This is the final point. I'm going to go to Justice Jackson. That is because race is a social construct. This is such an excellent point. And this is the same conclusion that I have come to. I always ask myself, like, what is the purpose and limitations, and why do we do and think the way we do? We should all ask ourselves that for everything that we've inherited. All ideas. What is the purpose of it? Does it do more harm than good? What are some new ways that we can approach it? What are the alternatives? Do we want to be defined by race, or do we want to use more colorblind approaches in the eyes of the law? As far as how we function, how we make friends, do we still want to resort to tribalism? There is still blatant racism in the black community as far as not wanting to associate with white folks. It is still prevalent. I got black folks that I'm friends with that they nonstop think that the white man is out to get them, and the white man is unfair, the white man's unjust, the white man can't be trusted, that the white man is using you, that the white man is in sheep's clothing, wolves in sheep's clothing. All this stuff. Cynicism. That's what critical race theory is. Cynical race theories. It creates cynicism, distrust, bitterness, resentment, and completely destroys all of the progress that we've made of trying to unify and heal between black folks and white folks, and to break down the limiting beliefs and bad social conditionings that were built and passed down generationally of blatant judgment of skin tone. That's all it is. Racial discrimination. That's all it is. General racial discrimination. Tribalism. I don't understand why Justice Jackson wants to continue that old way, conservative way of thinking. Why ought we to conserve tribalism? Ask yourself that. Why are we defending tribalism? Why is it worth continuing? What good has it done for us historically speaking? What bad has it done for us historically speaking? Does the bad outweigh the good? Does the good outweigh the bad? In the situation and context we're at right now, and timeline we're at right now, of us being extremely diverse and having babies with each other of different mixed races. And here's the other thing about it. It's crazy. No one really knows what they are, who they are definitively. Do you 100% know where your ancestors were 1,000 years ago? No. What about 500 years ago? No. 2,000, 3,000 years ago. Do you know? No, we don't know. Which is the limitation and flaw of tribalism. You confine yourself. You constrict yourself. You limit yourself on this social agreement that we all have that serves what purpose? The oversimplification, the dehumanizing nature of it. Tribalism is extremely dehumanizing. Tribalism is extremely disempowering. Tribalism is extremely divisive. There is a multitude of flaws in tribalism. It is an old way of thinking that we have moved past, and we must move past if we are to continue the idea of living in a nation with a multitude of different people that don't look alike, but are united by ideas, united by visions, united by the Constitution, united by common things we have in common. Like I said before. And Clarence Thomas understands this point. Race, here we go. Rather, these policies appear to be leading to a world in which everyone is defined by their skin color, demanding ever increasing entitlements and preferences on that basis. Not only is that exactly the kind of factionalism that the Constitution was meant to safeguard against, see the Federalist Papers, but it is factionalism based on ever-shifting sand. This is one way of putting it that I just explained. That it is constantly changing generationally. The bloodline, your lineage is constantly changing. Countries have changed, will change. Countries will collapse. Countries will merge. Countries will leave. That is because race is a social construct. We may each identify as a member of a particular race for any number of reasons, having to do with our skin color, our heritage, or our cultural identity. And over time, these ephemeral, socially constructed categories have often shift. They do shift. They are guaranteed to shift. For example, whereas universities today would group all white applicants together, white elites previously sought to exclude Jews and other white immigrant groups from higher education. In fact, it is impossible to look at an individual and know definitively his or her race. Some would consider themselves black, for example, may be quite fair-skinned, yet university admission policies ask individuals to identify themselves as belonging to one of the only few reductionist racial groups with boxes for only black and white, Hispanic, Asian, or ambiguous other. How is a Middle Eastern person to choose? Someone from the Philippines. Whichever choice he makes in the event he chooses to report a race at all, the form silos him into an artificial category, a man-made category, a destructive category, a divisive category, a disempowering category, a dehumanizing category. Worse, it sends a clear signal that the category matters. Correct. The category does not matter at all. But under our Constitution, the race is irrelevant. And the Constitution is correct in this. Because that category, the separation, did what to our nation historically? What did that old way of thinking, what were the consequences of that? That's the whole worldview that justified slavery, justified white supremacy, inspired it. Let's go to Jackson now. Woo! 3 hours, baby. Let's see where she's at. I got her on page 209. 209. Miss Jackson, Supreme Court Justice Jackson, dissenting opinion. Here we go. Gulf-sized race-based gaps exist with respect to the health, wealth, and well-being of American citizens. They were created in this distant past, but have undisputedly been passed down to the present day through the generations. Every moment these gaps persist is the moment in which this great country falls short of actualizing one of its foundational principles, the self-evident truth that all of us are created equal. I don't understand that. That makes no sense. Does she mean equal as in we're equal financially? What gaps is she talking about? Is she saying that that because there is differences racially that we're not equal? Is she saying equal financially, equal in as far as I don't get it. Like, is she? It seems like she's implying equal in opportunity and reflecting that in these gaps that she obviously sees. And I'm going to assume that she's going to push financial gaps. Yet today, the court determines that holistic admissions programs like the one that University of North Carolina, UNC, has operated consistent with Gutters as Bollinger are a problem with respect to the achievement of that aspiration rather than a viable solution as has long been evident to historians, sociologists, and policymakers alike. Justin Sotomayor, another dissenting opinion of trying to keep affirmative action, has persuasively established that nothing in the Constitution or Title IV, I think that's what that is, prohibits institutions from making race into account to ensure the racial diversity of admins in higher education. I join her opinion without qualification. Okay? I'm trying to figure out where in the Constitution, in the 14th Amendment, 13th Amendment, that makes clear we're all equal and you're not going to be judged, or there should be no law within the Constitution, within the eye of the law, that we should imply justification of using color to bring up or bring down anyone. I wrote separately to expound upon the universal benefits of considering race in this context, in response to a suggestion that has permeated this legal action from the start. Students for Fair Admissions has maintained both subtly and overtly that it is unfair for a college admissions process to consider race as one factor in a holistic view of its applicants. This contention blinks both history and reality in ways too numerous to count. But the response is simple. Our country has never been colorblind. Our country has never been colorblind. Okay? What consequences did we experience because of the colorblind, of the opposite of colorblind, which is racism, discrimination, grouping, compartmentalizing individuals, generalizing humans? I don't have to answer that. It's blatantly obvious. Given the lengthy history of state-sponsored race-based preferences in America, to say that anyone is now victimized if a college considers whether that legacy of discrimination has an equally advantage its applicant fails to acknowledge the well-documented intergenerational transmission of inequality that still plagues our citizenry. Again, so there is a lot of assumptions and premises under this statement. Intergenerational transmission of inequality, which applies. This is a very broad generalization in ignoring the complications of each individual's upbringing and why they are in the predicament that they're in right now. To make a generalization and ignore all other variables like individual responsibility, location, parenting, and just do a broad stroke of saying just because you're black and you live in America, you have experienced generational inequality it's inaccurate. You have to substantiate that. How do you quantify that? By saying specifically and only because of the past, that is the only reason why we see these gaps. And I'm assuming when she means inequality, she's probably talking about financial status and unemployment and below poverty lines, depending on the race. Let's continue. Miss Jackson. It is that inequality that admissions programs such as UNC help to address the benefit of us all. Because the majority judgment stunts that progress without any basis in law, history, logic, or justice, I dissent. Let me read that one more time. It is that inequality that admissions programs such as UNC helps to address. Okay, so again, this whole basis and progression of thought is positive discrimination is justified, and UNC is trying to correct these previous discriminations by, again, lessening the opportunity and disempowering and discrediting those with merit, oppressing those with merit that have earned the right, and trying to lift up those that didn't meet the merits, but we want to correct the past and make correct the past by basically doing two wrongs, discriminating, keeping discrimination as something to solve problems as a solution, using racism to solve the current issues that we have today. I don't get it. Why would you use the same tool, the same mindset that caused the problem in the first place to then resolve the problem? All you're doing is continuing this cycle of justified racism. That's what you're doing. You're creating a cycle without realizing it. Because the majority's judgment stunts that progress without any basis in law, history, and logic, or justice. I dissent. Imagine two college applicants from North Carolina, John and James. Both trace their family North Carolina roots in the year of UNC's founding of 1789. Both love their state and want great things for its people. Both want to honor their family's legacy by attending the state's flagship educational institution. John, however, would be the seventh generation to the graduate of UNC. He is white. James would be the first. He is black. Does the race of these applicants properly play a role in USC's holistic merits based on admissions progress? To answer that question, a page of history is worth a volume. Many chapters of American history appear necessary given the opinions that my colleagues in the majority have issued in this case. Justice Thurgood Marshall, very important, very intelligent, the first black Supreme Court justice of this nation. Sharp individual. He dealt with blatant discrimination. He dealt with crazy hate from white supremacy. And he's an example of, while everything is up against you, while the laws and system is up against you, he was still able to reach the highest courts in the land of America. Thurgood Marshall completely disproves, refutes the premises that Miss Jackson applies, because he is a living example of applying all of his will, using merit, and not relying on affirmative action, not relying on reverse racism for him to achieve positions of authority in this land. Let's quote Mr. Thurgood Marshall, Justice Marshall. 350 years ago, the Negro was dragged to this country in chains to be sold into slavery, uprooted from his homeland and thrust into bondage for forced labor. The slave was deprived of all legal rights. It was unlawful to teach him to read. He could be sold away from his family and friends at the whim of his master, and killing or maiming him and was not a crime. The system of slavery brutalized and dehumanized both masters and slave. Slavery, end quote. Miss Jackson is now speaking here. Slavery should have been and was to many self-evidently dissonant with our avowed founding principles. When the time came to resolve that dissonance, I know that word, but I'm gonna look it up. Give me a sec here. Dissonance. Lack of agreement. A tension or clash resulting from the combination of two disharmonious or unsuitable elements. Okay. 11 states chose slavery. With the Union's survival at stake, Frederick Douglass noted black Americans in the South were almost the only reliable friends the nation had. And but for their help, the rebels might have succeeded in breaking up the Union. After the war, Senator John Sherman defended the proposed 14th Amendment in the manner that encapsulated our Reconstruction framers' high sentiments. We are bound by every obligation by the black Americans' service on the battlefield, by their heroes who are buried on our case, by their patriotism in the hours that tried our country. We are bound to protect them and all of their natural rights. To uphold the promise, the framers repudiated this court's holding in Dred Scott v. Sanford by crafting Reconstruction amendments and associated legislation that transferred our Constitution and society. Even after the second founding, when the need to right historical wrongs should have been clear beyond cavil, opponents insisted that vindicating equality in this manner slighted white Americans. So when the Reconstruction Congress passed a bill to secure all citizens the same civil rights as enjoyed by white citizens, President Andrew Johnson vetoed it because it discriminated in favor of the Negro. Do you notice here why the obsession of race-based measurements and race-based who gets the upper hand, who gets oppressed or the short end of the stick? Because truly, Andrew Jackson and the people at this particular time that depended on slavery, depended on the Negro as free labor, cheap labor, and affecting their means of making a living, genuinely felt like it discriminated against white folks, was affecting their livelihood, and it was in favor of the Negro, as said here by Andrew Johnson. I'm not defending this guy at all. I disagree with him strongly. The point I'm making here is, depending on your perspective, you can always argue. You're in this argument of what benefits the white man and what benefits the Negro. And it's always this back and forth. Instead of you're constantly in this division. You're constantly in this disagreement because you're doing this mass generalization of tribalism versus tribe versus tribe. What the founding fathers and the second founding was attempting to do was to destroy that old way of tribalism, of colorism, that dehumanized people, that was the most divisive way to function within a civilization, and was impossible to continue that way if we truly wanted to heal the nation and move forward, move past slavery. That attitude and the nation-associated retreat from the Reconstruction made prophecy out of Congressman Stevens fear that those states will all keep up this discrimination and crush to death the hated freedmen. This is correct. How do you expect an economy of the South that they genuinely were you're messing with their livelihoods? All I'm doing is giving you their perspective. And context matters. When you're messing with their livelihood and ends to feed their family and their wealth, great wealth that they had, and you're telling them you no longer can use this system to make a lot of money. You have to completely restructure your whole business, really, your whole economy in the South, because the South was very dependent on this. They're going to be pissed. Obviously, they're going to be pissed and not happy about that. And they're going to challenge the hell out of that. And they're going to be angry about that. The whole transition at that particular timeline was so difficult. Things were tense. I mean, just put yourself in the shoes of the white man. Really, just and also the black folks. You got black folks that wanted revenge. You got some that wanted to be peace and wanted to be equal and wanted to be equal in the eyes of the law and were forgiving. And you had some that wanted revenge, were distrusting and wanted to work on their own and be separate and segregated from the white man. There was differences of opinion in this timeline of in the black side of what we should do, what we ought to do. And it took a while for us to make ends meet. We had to educate ourselves, and we did. We tried to do black businesses, black banks, black schools and educations. Booker T. Washington pushed for that. Beautiful. And you had white folks that were angry and had a white inferiority complex where they just simply, again, resorting to that tribalistic thinking that made them act the way they did. Tribalism to justify attacking the other tribe because they didn't want, they saw them as competition. They saw that the black man was bringing themselves up, educating themselves, dressing well, speaking well, learning the law, learning to defend themselves, bearing arms and going in armed militias, using the Second Amendment, weaponizing and using the Constitution. Then that's when you start seeing instances of the KKK and these white supremacist things. Right? it wasn't pretty. There was nothing pretty about it, right? And the founding fathers and a lot of congressmen, they understood this was going to happen. It was going to be ugly. There was no way around it on both sides. I mean, I can only imagine living in this particular timeline, how difficult it is from both perspectives. If I was black and I would be angry as hell, and I may do some crazy thing of seeking revenge because maybe they killed my mother, maybe I saw them whip my father to death, maybe they took my child, maybe they raped my wife, whatever, it's anything, all the brutal stuff that was happening back then, and I may want to seek revenge. The ability to just to experience that amount of trauma and hate, and then seek peace and harmony and forgiveness, very difficult task to do. But there was black folks, a lot of black leaders that genuinely calmed down and organized the black folks to say, we just want to be equal. We just want the Constitution to be applied to be given to us, to be equal under the eyes of the law. All right, let's continue with Miss Jackson here. But in almost every instance, the court chose to restrict the scope of the second founding. Thus, 13 years pre-Plessy and the civil rights case, our predecessors in this court invalidated Congress's attempt to enforce the Reconstruction Amendments via the Civil Rights Act of 1875, lecturing that there must be some stage when black Americans take the rank of a mere citizen and ceases to be special favorite of the law. But Justin Harlan knew better. He responded, what the nation through Congress, quote, what the nation through Congress has sought to accomplish in reference to black people is what had already been done in every state of the Union for the white race, to secure and protect right belonging to them as freemen and citizens, nothing more. Justin Harlan dissented alone. Okay, we're talking about the same stuff, but this is just from the perspective of Miss Jackson. Clarence Thomas already talked about Mr. Harlan, Justice Harlan being the great dissenter in this particular timeline, and making the case of color blindness. And the portrayal that this court enabled had concrete effects. Enslaved black people had built great wealth, but only for enslavers. No surprise, then, that freedmen leaped at the chance to control their own labor and to build their own financial security. Still, white settlers often simply refused to sell their land to blacks, even when not selling them was economically foolish. To bolster private inclusion, states sometimes passed laws forbidding such sales. The inability to build wealth. Through that, most Americans of means forced black people into sharecropping roles where they somehow always tended to find themselves in debt to landowner, where the growing season closed and no hope of recourse against the ever-pressing cooking of the books. Sharecropping is but one example of race-linked obstacles that the law and private properties laid down to hinder the progress and prosperity of black people. Vagrancy laws criminalize free black men who failed to work for white landlords. Many states barred freedmen from hunting or fishing to ensure that they could not live without entering a de facto reenslavement as sharecroppers. A cornucopia of laws, cornucopia of laws banning hitchhiking, prohibiting encouraging a laborer to leave his employer, and penalizing those who prompted black settlers to migrate northward, ensured that black people could not freely seek better lives elsewhere, and where statutes did not ensure compliance, state sanction and private violence did. Thus emerged Jim Crow, a system that was, as much as anything else, a comprehensive scheme of economic exploitation to replace the black codes, which themselves had replaced slavery, form of comprehensive economic exploitation. Meanwhile, as as Jim Crow ossified, the federal government was giving away land on the western frontier, in which the opportunities for upward mobility and a more secure future over the 1862 Homestead Act three-quarter century tenure, black people were exceedingly unlikely to be allowed to share in those benefits, which by one calculation may be advantage approximately 46 million Americans living today. This is interesting. The Homestead Act, three-quarter century tenure, black people. Okay, so let me see. Let's look up the Homestead Act here. I just need a simple go here. The Homestead Act were several laws in the United States in which an applicant could acquire ownership of government land or public domain, typically called homestead, in all more than 160 million acres of public land, or nearly 10% of the total area of the United States, was given away free to 1.6 million homesteaders. Most of the homesteaders were west of the Mississippi River. An extension of homestead principles and law, homestead acts were expression of free soil policy of Northerners who wanted individual farmers to own and operate their own farms, as opposed to Southern slave owners who wanted to buy up large tracts of land to use slave over, thereby shutting out free white farmers. Interesting. So let me read that one more time, make sure I understand. Interesting. For a number of years, individual congressmen put forward bills providing for homesteading, but it wasn't until 1862 that the first Homestead Act was passed. The Homestead Act opened millions of acres. Any adult who have never taken up arms against the federal government of the United States could apply. Women and immigrants who had applied for citizenship were eligible. Several additional laws were enacted in the late 19th and 20th century. The Southern Homestead Act of 1866 sought to address land ownership and equality in the South during Reconstruction. It explicitly included Black Americans and encouraged them to participate. And though rampant discrimination and systematic barriers and bureaucrats inertia considerably slowed Black gains, the 1866 law was part of the reason within the generation after its passage. By 1900s, one quarter of all Southern black farmers were farm owners. I don't know what that number is. Does Miss Jackson bring that up? I wish she would bring that up. The Southern Homestead Act of 1866. You know how it is. Usually people will bring up arguments and they'll tell you half of it that paints a picture and solidifies the narrative and argument they're trying to give. So, but it explicitly included Black Americans to encourage them to participate. The Timber Culture Act 1870 granted land to claimant who requires to plant trees. Let me study this one here. The Southern Homestead Act of 1866 enacted a break a cycle debt during Reconstruction following the American Civil War. Prior to this act, blacks and whites alike were having trouble buying lands. Sharecropping and tenant farming had become ways of life. This act attempted to solve this by selling land at low prices so Southerners can buy it. Many people, however, could still not participate because the low prices were too high. Okay, so I can understand how that can discriminate against black folks in this particular timeline. A second Freeman Bureau bill was introduced December 5th, 1865, but was vetoed and weakened before eventually overriding a second veto by President Andrew Johnson. This guy was definitely a devout racist. Championed by General Oliver O. Howard, chief of the Freeman Borough, with the support of Theda Stevens and William Fredison. Stevens was definitely a abolitionist, if I remember correctly. He was a radical Republican. Yep. And this guy as well. The Southern Homestead Act was proposed to Congress and eventually passed and signed into law by Andrew Johnson, 1866. Going into effect immediately, the Southern Homestead Act opened up 46 billion. Oh, excuse me, 46 million. I thought that was a comma there. 46 million acres or 190,000 kilometers of public land for sale in the southern states: Alabama, Arkansas, Florida, Louisiana, Mississippi. The land was initially in parcels of 80 acres. Okay, June 1866, therefore. Until January 1st, 1867, the bill specified only free blacks and white unionists would be allowed to access these lands. Accordingly, the primary beneficiaries for the first 6 months were freedmen who were in desperate need of land to till. However, the law encountered many obstacles, notably Southern bureaucrats often did not comply with the law or with the orders of the Freedmen Bureau, notably not informing blacks of their opportunity to acquire land. Terrible. Violence from competing whites, poor quality of the land, and poverty of the farmers who were often unable to effectively use the land without farming money to invest. Ultimately, before too much land was distributed, the law was repealed June 1876. Nevertheless, free blacks entered about 6,500 claims to the homestead, and about 1,000 of these eventually resulted in property certificates. So, black folks were given land in the South. I don't know what the population and what the percentage is in the South in this particular timeline. But it is interesting to study that. But the claim that black folks didn't get land, or now they definitely had barriers, obviously so, 100%. They weren't informed. I mean, I can understand that. Definitely terrible. Black people were exceedingly unlikely to be allowed to share those benefits. Exceedingly unlikely. I mean, again, like, these are exaggeratory. These are very exaggerated claims here. Because for one, she's withholding the Southern Homestead Act that we just read here. Just focusing on the Homestead Act seems pretty dishonest. Despite these barriers, black people persisted. Their so-called Great Migration northward accelerated during and after the First World War. Like clockwork, American cities responded with racially exclusionary zoning and similar policies. As a result, black migrants had to pay disproportionately high prices for disproportionately subpar housing, nor did migration make it more likely for black people to access home ownership, as banks would not lend to black people, and in the rare cases banks would fund home loans, exorbitant interest rates were charged. With black people still locked out of the Homestead Act giveaway, it is no surprise that when the Great Depression arrived, race-based wealth, health, opportunity gaps were the norm. Federal and state government selective interventions further, and this is another thing. Like, this is a side point here, but America went through a Great Depression, and the Great Depression, actually, there was a depression that the South went through after the abolishment of slavery, after the Civil War. The country as a whole went through a depression, and then the South went through a depression, and they had to go through reconstruction of the whole economic landmass in the South. Not only that, our nation was still pretty poor. So the benefits of the past it's very hard to just measure that because we don't know who suffered from the depression we went through economically after the Civil War. Also, the Great Depression that happened in the early 1900s that affected a lot of people greatly. And the stuff that was inherited in the 1800s, late 1800s, into the Great Depression era, that wasn't guaranteed. There's no guarantee. How do you know that that continued after a Great Depression where there was, I mean, what were the numbers for unemployment? Great Depression unemployment rate. Almost 13 million were out of work. That's a lot of people. That is a lot of people. Let's see if they have something by race. I don't know if they do. Probably. See what it says here. What is this? (1920) African Americans are looked upon as lower class individuals as a result of very low paying jobs. Now, just imagine the economic crisis of such situation. It will be chaotic. All right, let's get back to the main thing here. And I'm just really getting off into the weeds here. I want to finish Miss Jackson's stuff. Do do do. Green meant safe. Red meant risky. So this is zoning, the color codes that we had. Black people earned the red designation. Similarly, they consider the Federal Housing Administration, created in 1934, which ensured highly desirable bank mortgages. Legibility for this insurance required an FHA appraisal of the property to ensure a low default risk, but nationwide it was FHA established policy to provide no guarantees for mortgages to the African American or whites who might lease to African Americans, irrespective of credit worthiness. No surprise then that between 1934 and 1968, 98% of FHA loans went to white Americans, with whole cities, ones that had a disproportionate large number of black people due to housing segregation, sometimes being deemed ineligible for FHA intervention on racial grounds. The veteran administrations operated similarly. One more example: the Federal Home Loan Bank Board charter ensured the regulated state. Again, so she's making the case, and rightfully so. These are great points. It's still a weak argument to say that the Constitution protects and justifies reverse discrimination of bringing down another race to bring up another race, of endorsing and continuing tribalism. It's just not protected constitutionally. The Constitution is not a economic guarantee. It has nothing to do with economics. As far as guaranteeing outcomes, economically speaking, the Constitution is not meant for that. We don't want the Constitution to be for that. There's a very slippery slope to make the Constitution an economic guarantee within race. All you're going to do is have grievances of people going back and forth to say, well, you allow this for the black folk. Why can't you do the same thing for Asians? Why can't you do the same thing for whites? Why can't you do the same thing for Hispanics? What about illegals? You did it for black folks, you can do it for illegals. You did it for black folks, you can do it for white folks. It's terrible precedent. The upshot of all this is that due to the government policy choices in the suburban shaping years between 1930 and 1960, fewer than 1% of all mortgages in the nation were issued to African Americans. Thus, based on their race, black people were locked out of the greatest mass-based opportunity for wealth accumulation in America. For the present purposes, it is significant that it in so excluded black people government policies affirmatively operated, one could say affirmatively acted to dole out preferences to those who, if nothing else, were not black. Those past preferences carried forward and are reinforced today by, among other things. Okay, they're still enforced today. Those past preferences carried forward and are reinforced today by, among other things. I would like for her to. She should definitely you should definitely expand on this claim here. The benefits that flow to homeowners and to holders of other forms of capital that are hard to obtain unless one already has assets. This discussion of how the existing gaps were formed is merely illustrative, not exhaustive. I will pass over Congress repeated crafting of family, worker, and retiree protective legislation to channel benefits to white people, thereby excluding black people from what was otherwise a revolution in the status of most working Americans. I will also skip how the GI Bill, creation of middle class America by giving $95 billion to veterans and their families between 1944 and 1971, was deliberately designed to accommodate Jim Crow. So, 2, will I bypass how black people were prevented from partaking in consumer credit market, a market that helped white people who could access it build and protect wealth. Nor will time and space permit my elaborating how local officials' racial hostility meant that even those benefits that black people could formerly obtain were unequally distributed along racial lines. And I could not possibly discuss even every way in which, in light of this historical history, facially race-blind policies still work race-based harms today. Racially desperate tax system treatment, the disproportionate location of toxic waste facilities in black communities, or in the deliberate action of governments at all levels in designing interstate highways to bisect and segregate black urban communities. The point is this: given our history, this is a weak argument too, because it's as if black folks are trapped within these areas that are still experiencing or still built in a way that's segregated, while in a particular timeline that is true, black folks are not bound by that. The toxic waste stuff, that's a good fact. That being said, though, again, does it justify the Constitution going back and contradicting itself, of it being a race based document, or a, under the eyes of the law, equal? The thing about it is that no one is stopping you from doing this in the private sector of fixing all these problems. If you want to create a nonprofit, if you want to unite black people to assist those to get out of these facilities, to lobby against allowing these facilities to continue in black communities, black people have trillions of dollars of wealth. Let me look at that number. What is the wealth, the dollar amount wealth within the black community? Here. Oh, crap. Let me look. Let me do it this way. How much black American spend here? There you go. The buying power. Well, I don't understand this. The buying power of the African American black consumer buying power is projected to reach 1.4 trillion by 2024. Black buying power reached $1.6 trillion. That's a lot of buying power the African Americans can use together if they choose. No one's stopping you to saying, listen, we're going to invest in black businesses. We're going to help black, you can't legislate that. You can't use the law. But if you want to consent to say, I'm only going to spend money in black business, then if that's what you truly think is needed to fix the black community, then go do it. I want to invest in the black community. I want to mentor for black community. I want to be like, if that's what you truly want to do, then make that your purpose. You must weaponize the dollar. The dollar is a weapon that can be used to acquire power, to gather, to redistribute. Like what capitalism is very, it's not too complicated, but one essence of capitalism is that the redistribution of wealth, you can choose how it's where the dollar goes. If you want to redistribute your wealth in your local area and spend in your local area that is also your own people, your own race, then you can do so. You don't have to be buying from Nike. You don't have to be buying Jordans. You don't have to be buying from Walmart. You don't have to buy from Amazon. You can support black supermarkets, black banks. No one's stopping you from doing that. I mean, it's pretty common in a lot of other races that they do that. The question still stands. Where is the argument to justify that the Constitution protects it, that the Constitution allows it, that the Constitution should allow it? I know that she was always going to, I only know that, I mean, really the only argument that you have is just to list off all of the blatant discrimination and economic hardships that black folks, I mean, this is common. We know this. We know that black folks went through hardships. We know that law was used to bring down and suppress and dehumanize and disempower black people. Now, to what degree do black people still have obvious effects to it today? I don't know. Because again, we have 1.5 million black millionaires, 1.5 million black millionaires in America. Your chances of success is in America as a black man are higher than anywhere else in the world. And also, we have to look at the culture within the black community. How does the black community use its dollar and circulate it within its own people? Are they united? You know, it. If you really want to, be a community and lift each other up, but it's just there's a lot of things to it that I'm not going to get into right now. I want to finish Miss Jackson's dissenting opinion. The point is this: given our history, the origin of persistent race-linked gaps should be no mystery. It has never been a deficiency of black Americans' desire or ability to, in Frederick Douglass's words, stand on their own legs. Rather, it was always simply that, just as Harlan recognized 140 years ago, the persistent and pernicious denial of what had already been done in every state of the Union for the white race. History speaks in some form of it. It can be heard forever. The race-based gaps that first developed centuries ago are echoes from the past that still exist today. By all accounts, they are still stark. Start with the wealth and income. Just 4 years ago, in 2019, black family median wealth was approximately $24,000. For white families, that number was approximately 8 times as much, about $188,000. This is interesting. I want to know what you got these numbers. Median wealth. Let me look that up. I'm not sure where she's getting those numbers from. 2014, 2016, the average household pre-tax income. Average was Asians 93,000. The lowest blacks or African Americans 48,800. Or excuse me, 48,800. What about white Americans? Do 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 do. So, pre-tax annual income U.S. household by race and ethnicity 2014 to 2016 combined. The mean African Americans 48,000, Hispanic Americans 55,000, American Indian, Alaska Native 60,000, multi-race. White is 77,000, Asians 93,000. The 25th percentile, 50th percentile, 75th percentile, that's the 90th percentile. You can see the numbers vary. The 10th percentile, 7,360. Hispanics, whites, 13,163. Asians, 11,000. These numbers are very interesting. Make sure I zoom in so everyone can see it. But there isn't any great disparity here. I'm not sure where she gets her number. The median wealth. When we're looking at the black family, median income or pre-tax annual income combined for these particular years. I mean, I guess depends on what year you're looking at. I don't see any great disparities here. I do see Asians absolutely destroying. I mean, Asians are just kicking ass. All right, start with wealth income just before you go. In 2019, black families mean, or was it possibly 8 times as much? 100. I have to look at these numbers. I'm not sure how she's getting these numbers. These wealth disparities exist at every income and education level. So, on every average, white family with college degrees have over 300,000 more wealth than black families with college degrees. This disparity has also accelerated over the time from roughly $40,000 gap between white and black household median net worth in 1993 to roughly $135,000 gap in 2019. Median income numbers for 2019 tell the same story: 76,000 for white household, 98,000 for Asian household, 56,000 for Latin household, and 435 for black household. These financial gaps are unsurprisingly in light of the link between home ownership and wealth. Today, as was true 50 years ago, black home ownership trails white home ownership by approximately 25%. Moreover, black American homes relative to white Americans constitute a greater percentage of household wealth, yet tend to be worth less, are subject to higher effective property taxes, and generally lost more value in the Great Recession. That is true. I will say that whenever recession hits, African Americans are definitely affected the worst. That is so true. I've seen those numbers as well. Black folks are just affected by it. It's. I would like to look into the numbers of why that is, outside of just the general conclusion of it being history and slavery and the white man. From those markers of social and financial wellness flow others. In most state flagship higher education institution, the percentage of black undergrads is lower than percentage of black high school graduates in that state. Black Americans in their late 20s are about half as likely as their white counterparts to have college degrees. And because lower income families and wealth force students to borrow more, those black students who do graduate college find themselves 4 years out with about 50,000 in student debt, nearly twice as much as their white counterparts. As for post-secondary professional arenas, despite being about 30% of the population, black people make up only about 5% of lawyers. Such disparity also appears in the business realm, of roughly 1,800 chief executive officers to have appeared on the well-known Fortune 500 list. Fewer than 25 have been black. Again, I mean, so if this is her metric. The metric is we only have 25 that have been black. Roughly 18 chief executive officers appear to be. I mean, I don't. Only 6 or 25 have been black. 22. Only 6 are black. Okay, I see. But again, this isn't an argument of the constitutionality of it. This is just you trying to justify why we should ignore the second founding of the Constitution, and why we should weaponize and use we should use a living Constitution, be flexible with the Constitution to justify reverse discrimination. Probably due to this disappropriate denial of forgivable loans. Health gaps track. She's just going to continue with the differences, and I get it. It's fine. These are great points. They're weak points in the context of Is the Constitution the proper solution to resolve these differences, to truly fix these issues? She also didn't substantiate the positive effects of affirmative action. I mean, there should be data out there. So affirmative action did work. It should have closed some gaps in some of these areas that she's complaining about. I mean, we've had affirmative action for how many years? Affirmative action was passed in 1965. Excuse me, 1978. Yeah. So 1978, the Supreme Court basically made the claim that it is justified, it is okay, it is constitutionally protected for race-based judgments to be used as a criteria for accepting applicants, and so forth. So 1978, 2023. Oops. That's 45 years. So 40 years, the theory has been allowed. The solution has been applied. Now, I mean, I would like to know the numbers of how many colleges actually implemented this. But what has been the positive effects of affirmative action? Where are the numbers for that close the gap? Because she's talking about recent things, but she's not giving obvious evidence of what good thing is done. And even then, the arguments don't justify the constitutionality of it. So I'm going to skip through a lot of this stuff because, again, it's just, I'm not seeing anything in regards to the Constitution. She's just going to continue to talk about, okay, here we go. We return to John and James now. With the history in hand, it is hardly John's fault that he is the seventh generation to graduate from UNC. UNC should permit him to honor that legacy. Neither, however, was it James or his family's fault that he would be the first. Then UNC ought to be able to consider why. Most likely 7 generations ago, when John's family was building its knowledge base and wealth potential on the university's campus, James... Okay, hold on. What? Six generations ago, the North Carolina Redeemers aimed to nullify the results of the Civil War through terror and violence, marauding, in hopes of excluding all who looked like James from equal citizenship. 5 generations ago, the North Carolina Red Shirts finished the job. 4 and 3 generations ago, Jim Crow was so entrenched in the state of North Carolina that UNC enforced its own Jim Crow regulations. 2 generations ago, North Carolina governor still railed against integration for integration's sake. And UNC black enrollment was, don't know that word. So at bare minimum, 1 generation ago, Jane's family was 6 generations behind because of their race, making John's 6 generations ahead. Whoa, this is a crazy leap. Oh my gosh. Is this a Supreme Court justice? Whoa, this is terrible logic. And again, It's terrible logic because you can't connect the dots and guarantee that the 6 generations is that James is still benefiting from the 6 generations. Also, you don't need race to to inform UNC in your application that you are the first generation. You don't need to say that. There's no need for that. These stories are not every student's story, but they are many student stories. To demand that colleges ignore race in today's admission practices and thus disregard the fact that racial disparities may have mattered for where some applicants find themselves today is not only a affront to the dignity of those students from whose race matters, it also condemns our society to never escape the past and explains how and why race matters in the very concept of who merits admission. Permitting, not requiring colleges like UNC to assess merit fully without blinders on plainly advances, not thwarts, the 14th Amendment's core promise. What's the core? The core promise of the 14th Amendment is color blindness. It's to abolish the tribalism, the old way of thinking. Why do we choose to conserve this way of thinking? Are we not all Americans? UNC considers race as one of the many factors in order to best assess the entire unique import of John's and James' individual lives and inheritance on an equal bit inheritance. So this is a false premise. How do you know that James' family is rich and wealthy? We don't know that. How do we know also that UNC is discriminating off the basis of skin tone versus merits? If John outperforms as far as his GPA and his presentation and his application looked great, he's going to get in. Has nothing to do with black or white of any sort. So there's no need to consider race. Consider race to best assess what factors? There's no need for it. You're not defined by race. Race has nothing to do with anything at all. Is this person a good fit for our college or not? And they have different barriers that they have in place to make sure. Recognizing all this, UNC has developed a holistic view process to evaluate. Hold on. Doing so involves acknowledging, not ignoring, the 7 generations worth of historical privileges. What? And disadvantages that each of these applicants was born with when his life journey started a mere 18 years ago. What? What privileges? There are privileges that we have on all races. There are people that don't have any privileges and still have to work and have more barriers that they have to overcome. Also, it makes no sense. It makes no sense to me why people won't want to presume that just because one generation does well, that the next that just passes down. Now, I can understand, economically speaking, some families want to save for colleges for their kids and the whole debt situation. I can understand that the argument. And black people having to go into more debt. I understand that argument because their families just inherited not being able to have family for them to go to college. I understand that perspective. That being said, there are means for you to get around that, like joining the military and scholarships and getting into sports, scholarships. I actually want to know that statistic of how much scholarships benefit what race more or less. I wonder what that stat is. Sport scholarship by race. I don't know if anyone's. Oh, here we go. Interesting. In per capita. Let's see what it is here. Professional athlete. This is way too broad of a. Again, it's just broad. 25. What percentage of athletes are black? 25%. The percentage of black athletes and team owners are not have has not changed much, with black people accounting for 70% of NFL players, 81% of NBA players. Okay, it's blatantly obvious black folks dominate the NBA and the NFL. Oppressive, right? How oppressive is that? So oppressive. Let me see. D1 athletes. That's not the question. The question is scholarships. What race is the most athletic? African Americans. Look at that. The question is scholarships through what a generation. Do 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 do. A study released Tuesday, University of Massachusetts, that New England colleges often favor minority students who meet minimum admission standards over white students who are just as or even better and qualified. Look at that. Interesting. Miss Jackson, do you put that in there? I would like to know, not D1 athlete. I just want to know who receives the most amount of scholarships by race. Oh, here we go. Look at this. Amongst minority groups, African Americans or blacks who receive a greater number of athletic scholarships, 22.8%, compared to other minority groups, other Asian Hispanic groups. I mean, obviously, because if you're just doing this off the raw numbers, yeah, but I want to go on a per capita. See, this is the stuff that's frustrating. In 2018, college enrollment rate was higher. Yada yada yada. See this? See, I can't. No one's broken down these numbers. Come on. 69% of athletes. I mean, obvious. That's obvious. You have more white people. This is a terrible way to break down statistics. There's more white people in the U.S., so obviously you're gonna have more white people in athletics. What I'm talking about is in proportion of their population, which is a lot of times where you see people break down things. I mean, like the medium household income, individual household income in proportion with their population. So interesting how people manipulate things whenever it's in their favor. And all I'm doing is just using the same standard that they're using to truly understand a greater picture of that. Anyways, let's continue here. I'm almost at hour 5. This is crazy. Recognizing all this, UNC has developed a holistic view, yada, 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 must submit standardized test scores and other conventional information, but applicants are not required to submit demographic information like gender or race. UNC considers whatever information each applicant submits using a non-exhaustive list of 40 criteria, group into each criteria. Drawing into those 40 criteria, UNC staff members evaluate John and James would consider with respect to each of his engagement outside the classroom. Persistence of commitment demonstrates capacity of leadership. So where does race come in? According to UNC admission policy documents, review is also consider the race, ethnicity, but so again, I mean, we just saw here the New England, or I mean, this is a study. A New England study often favor minority students who meet minimum admission standards over white students who are just or even better qualified. I would love to look at this study. That is an example of affirmative action in action. And yes, the race of ethnicity of any student may or may not receive a plus in the evaluation process depending on the individual circumstance revealed in the student's application. Stephen Farmer, the head of the UNC's office, confirmed a trial under oath that UNC's admission process operates in this fashion. Thus, it is crystal clear that every student who chooses to disclose this or her race is eligible for such a race-linked plus, just as any student who chooses to disclose his or her unusual interests can be credited with interests, yada, yada, yada. Let's just continue. There are no race-based quotas for UNC holistic review process. And that's true. That doesn't mean that they're not judging you off of race and trying to correct the past of the of racism in UNC by judging you by race and rejecting those that are more qualified by race to prioritize black folks to get in, even if they meet minimum. So it's no longer a meritocracy. You're trading off merits for what can say one can say reparations, correction, discrimination, positive discrimination, whatever euphemism you want to come up with for blatant racism. More than that, every applicant is also eligible for diversity linked plus beyond race. More generally and notably, UNC understands diversity broadly, including socioeconomic status, first generation college status, political beliefs, religious beliefs, diversity of thought. Okay. A plus by its nature can certainly matter in an administration case. But make no mistake, when an applicant chooses to disclose his or her race, UNC treats that aspect identity on par with other aspects of applicant identity that affects who they are. Just say like where one grew up or medical challenges one has faced, and race is considered alongside other it serves no great purpose. It doesn't. It's clearly, I mean, looking at it here, a study shows that minorities get more privileges than their counterparts of white folks that are even better qualified. So yes, it is being used wrongfully. It is being used to discriminate those that are not black. I mean, that's the whole premise. That's the whole motive behind those that challenged this. They were experiencing discrimination. Thousand applicants with the capacity to take full advantage of the opportunity to attend and contribute to this prestigious institution. Thus, merit admission, and UNC has concluded that meriting required in the full person, which means taking seriously not just SAT scores, whether the applicant plays a trumpet, but also anyway. I mean, okay, what does race have to do with anything? Tell me, someone explain to me, other than to assess this whole narrative of oppression and reparations and correcting the past and all this stuff and positive discrimination. Like this, all this stuff here is just nonsense. It doesn't justify why race is important. It permits but does not require them to value John's identity as a child of UNC alumni, or perhaps but it doesn't require it. But people know that if you say your race and you're a minority, that you're going to get in, you're going to get privileges over those that are not the minority that comes from the background that we're trying to use, trying to correct the things of the past. Understood properly, then, what the SFFA's correct characters as a unfair race-based preferences cashes out in a holistic system. Look at this. This like stuff like this is just, it makes me puke. Holistic system. It's again, all these names to hide the discrimination that people experience that are not black. To personalize assessment of advantages and disadvantages that every applicant might and receive by the birth plus yada yada yada. Individuals' resilience and likelihood of enhancing the UNC campuses. There's also forecast as potential. Notice how she's strictly focusing on UNC. Other colleges use this. A lot of other colleges use this still to this day, or use affirmative action. Okay. It also forecasts its potential for entering the wider world upon graduation and making a meaningful contribution to the larger collective societal goal that the Equal Protection Clause embodies. So this is adding more than what the text and the original intent of this doctrine, of the words, of the amendments, than what it was. It embodies it. It implies it. That's adding to the text. That's you imposing meaning into the text. That's you imposing what you think it ought to mean in this current moment versus what it meant whenever it was written. This is the flaw of living constitutional interpret, the evolution constitutionalists, whatever word that you want to give them. These are people, typically liberal judges. I don't know what the definition is, but these are judges that impose meaning for in the modern sense of what it should mean today. Living constitution, that's the proper word. Living constitutional. It's living today. It isn't living whenever this was written today or written in the past. The Equal Rights Protection Clause. It doesn't say that explicitly. A guarantee that the United States of America offers genuine equal treatment to every person regardless of race. That is correct. Equal treatment, yet there are people that are not of the black race that are being treated differently. There are white people that are being discriminated against. Furthermore, and importantly, the fact that UNC holistic process ensures a full accounting makes it far from clear that any particular applicant of color will finish ahead of any particular non-minority applicant. For example, as the district court found, a higher percentage of most academically excellent in-state black candidates at SFFA experts determined academic excellence were denied admissions, and similarly at similarly qualified white Asian American applicants, that if nothing else is indicative of genuinely holistic process, it is evident that both in theory and in practice, UNC recognizes that race, like any other aspect of a person, may bear on where both John and James start the admission relay. I mean, you imply that by saying I'm the first generation to go to the school. That's how you say it. There's no need for race doesn't communicate anything else outside of that, other than the arguments of the historical oppression. And again, we're not arguing that. We're arguing, is it constitutional? Is this justified under the law of the land? In all 50 states, the federal law. But will not fully determine whether either eventually cross the finish line. The majority seems to think that race blindly solves the problem of race-based disadvantage. But the irony, okay, so this is a conflict of visions, truly, between a lot of black thinkers of today, Martin Luther King as well, Martin Luther King's speech of I Have a Dream is pushing for blindness of skin tone blindness, color blindness. Why does she use? I don't know. I don't get why she uses the word race. It's kind of disingenuous. It's color. That's the most important. But race is another word for color, so it doesn't matter, I guess. But the irony is that requiring colleges to ignore and the race is just a very general term. It really is. But I get what she's trying to say. But the irony is that requiring colleges to ignore the initial race-linked opportunity gap between applicants like John and James will inevitably widen that gap, not narrow it. Okay, so give us evidence that it will narrow it. It's been 40 years. Where is the evidence that it will narrow it? Where is the evidence for that? Where is the evidence that reverse discrimination, reverse racism narrows the gap? And also, who consented? Did white folks and Asians consent to this system of judgment by skin tone, by color, by race? It would delay the day that every American has an equal opportunity to thrive regardless of race. So here finally she's starting to truly trickle in truly what she desires. Opportunity to thrive. We're a capitalistic system, or we're a mixed economy. But nowhere in the Constitution is there guaranteed to thrive. Guaranteed to. What do you mean thrive? Thrive how? Who? Everyone's got a different definition of thriving. Obviously, by the points that she made, it's finances. The Constitution does not guarantee financial, equal financial within the races. It's not equal. The Constitution is not an economic document. The pursuit of happiness versus the guarantee of the guaranteed of outcome. The opportunity. Sorry, I'm getting a brain fart right now. The opportunity of outcome. I'm trying to think of the word right now. I'm kind of blanking out. Sorry. You should the Constitution prioritizes equality of opportunity, not equality of outcome. That's what I'm trying to say. It seems like for some reason Justice Jackson truly, and I get it, may have good intentions. The road to hell is paved with good intention. And a lot of people that have had good intentions for good things and have done terrible stuff have there's a lot of things that while you may win the battle, you lose the war. There's a lot of things in this nation, in this particular timeline, that if we would have done reparations during the timeline of the Civil War and the abolishment of slavery, it would have been great. We would have been able to directly see those that are affected, and it would have been rightfully so. Could the nation afford it at that particular time? I don't think so. We just went through a war. We went through an economic depression. And I get it. Justice Jackson makes great points talking about the barriers, the legal barriers that the Southern blacks had to deal with of acquiring land around that timeline of the mid 1800s, late 1800s. It's a valid point. It's unfortunate that particular generation of black folks had to go through that. That being said, I care about and I'm focused on this generation of Americans and the future of America, and not continuing the old way of thinking. and not allowing the past to destroy the future and destroy hope for the future. We should be near the end here. All right. So SFA simply asks us to consider how much longer UNC will be able to justify considering race. Whatever the answer to that question was yesterday, today's decision will undoubtedly extend the duration of our country's need for such race consciousness. I don't understand. I don't want people to judge me, a black American, to just speak the language of Miss Jackson here. I don't want people to be conscious of my race. I don't. I want them to treat me like an American, treat me like any other human. That's it. I don't care about race consciousness. Now, you may care about race consciousness, but I don't. And I hope that my generation moving forward, we start to see less and less and less of this obsession with colorism, with color. Because the justification for admissions program that account for race is inseparable from the race-linked gaps in health, wealth, and wealth being that still exist in our society, the closure of which today's decision will forestall. She can't substantiate that because she can't support what gaps in these areas, health, wealth, well-being, etc. Where's the statistics within the past 40 years that it benefited black folks? Show us those studies. She's assuming that it's going to help black folks. To be sure, while the gaps are stubborn and pernicious, black people and other minorities have generally been doing better. Correct. But those improvements have only been made possible because the institutions like UNC have been willing to grapple forthrightly with the burden of history. This is crazy to just that the main causation for black people and minorities doing better is because it's. I mean, I guess you can generally make that claim that it's true. I guess you can make that general claim. But again, did race really need to play a role in this, though? I don't get it. SFFA's complaint about the indefinite use of race-conscious admissions programs then is a non sequitur. These programs respond to deep-rooted, here we go, objective, measurable problems that their definite end will be when we succeed together in solving those problems. Oh my gosh, this is a terrible argument. This is a terrible argument. What does that even mean? When everyone, like, what does that mean? When we can succeed together? What? We who? Black folks? Like, it's been so long since slavery was abolished. It's been so long. Now, I get the whole trickle down generation theory that she has. But even then, she doesn't have evidence to prove that the affirmative action had great benefits and is the main reason why black folks and other minorities are generally been doing better. I mean, black folks, in comparison to the abolishment of slavery, have been doing drastically better as time progresses. So is it a matter of time and black folks assimilating and fixing themselves and really getting into the free market, learning the free market, getting into these fields of law and doctors and getting into running a small business and farming and all this, et cetera, understanding the free markets and competing in the free markets like every other race does? This is the tear. This is. I mean, I'm gonna be honest with you. This is embarrassing that she even said this. When we succeed together in solving those problems, listen, you're never going to resolve all poverty. There's always going to be a lower class. There's always going to be people that are just lazy. There's always going to be people that just want free handouts and want to just tax the hell out of the working class. There's always going to be people that just weaponize history to get entitlements, to get free stuff. There's always going to be people like that. So it's just it's hard to quantify that, which is why it's terrible to just say, oh, whenever we all succeed and together, and this makes no sense. Maybe if she would have said once the median income of black people reaches 60,000, 70,000, that would have been that would have been better than what she said here. She should have, give a specific number, Either way, I still would have disagreed with it, but it's better than this vague, amorphous, measurement. Objectively measurable problems. Their definite end will be when we succeed to. Every race has problems. White folks have problems. That is a class issue, the lower class. Moving on here. Only while there are many perversities of today's judgment, the majority's failure to recognize that programs like UNC's carry with them the seeds of their own destruction is surely one of them. The ultimate goal of recognizing James' full story and potentially admitting him to UNC is to give him the necessary tools to contribute to closing the equity gaps. This word is just odd. Equity gaps. I really want to this is so interesting. Equity. Okay, the quality of being fair and impartial. Fairness? Yeah. That is a very vague, amorphous term there. Another amorphous term. Anytime someone just says vague, amorphous terms that are subjective, this is why meritocracy is better. This is why free markets is better than depending on people's feeling of when they feel fair, that fair is fair, and when they feel like their problems are no longer problems. I get it from an economic standpoint alone. You can definitely make an argument for that. But again, the Constitution is not the document, and it does not serve the purpose of economic corrections. Strictly. In addition, notably that end is not fully achieved just because James has admitted schools properly care about preventing racial isolations on campus because research shows that it matters for students' ability to learn and succeed while in college if they live and work with at least some other people who look like them and are likely to have similar experiences. So this needs to end. Okay? This limiting belief needs to end. Right? Like, I don't relate with you because, like, I'm a New Yorker. Was born in Bronx, New York. I was there briefly. I was raised all over the place. And I don't relate with people, like, I was raised mostly in Missouri, the Midwest. I don't really care or obsess about meeting other people from Missouri. I don't care. Like, okay, cool, we have that commonality. But for me to be a part, like to obsess about, like, oh, I can only relate and trust people from Missouri, and I can only talk to people from Missouri, or even my city. I was in a small cow town for the most part. I don't care. I don't talk to any of the people that are other than my parents. None of them in my small city that I was at do I talk to anymore, or I don't talk to them. I don't care for them. And also, there are plenty of people that join the military and they assimilate and get along with people from all different walks of life there just fine. When I joined the military, that was a great experience. I had the mind of I want to meet different people. I want to explore. I want to understand. I want to experience. I didn't have this whole thing of like, oh, I need to stay with my own people in my own city that look like me and were raised in the same environment as me. What is that? That is the flaw of tribalism. That's another flaw of tribalism. It really is. I could care less about where you're. I don't care about that. What does that serve? Okay, like racial isolation. Schools probably care about preventing racial isolation. What is this? I don't understand this worldview. This worldview needs to end. This is discrimination. Look at these new phrases of obsession of anti woke, or even not anti woke, anti racism to justify racism. We're going to use anti racism and racial sensitivity and racial consciousness to continue and justify racism and tribalism. The thing that caused my people, black people, to experience great traumas, tribulations, and problems. What? I don't get it. It makes no sense. I'm not persuaded. I really want, like, I agree with there's a lot of stuff I agree with Miss Jackson, especially her talking about the disparities and discrepancies that we have. I disagree with her conclusion of what the cause of that is and the solution that she has, right? Disagree with that wholeheartedly. That's fine. But her historical and her good intention that she has is all those things are admirable. I have high respect for Miss Jackson. That being said, there's some things that she's said here that are questionable, and if this is what's being taught in school, I'm glad I didn't go to school. I would probably be kicked out. Like racial isolation? What? Okay, we need our school, our education system really needs a revamp. And again, our goal and the ideal, and it should be. It's almost like I guess you can call it a virtue, but synonymous with us living in harmony and peace and being civilized. Those virtuous things. You must have color blindness to function in a society that we have right now and be able to assimilate with the multiple different ethnic groups that we have and different cultures that we have and embrace those. I had a customer today that she was Asian descent and she struggled a little bit with English. I could care less. You know, I understand Asian cultures. You take off your shoes when you enter the door. They're very polite and respectful. They eat certain foods. Like I don't say, oh, I relate more with the Asians or less with the Asians or than I do with anybody else. I don't impose that limitation when I go out and socialize with people. I always get excited and want to maybe learn and take in what other cultures do and ethnic groups do. Because there's a lot of great things that the Asian community does that I should replicate and mimic. So to say I should be stuck and confined to my own people and my own culture. What if your culture and what if your location you were raised in is garbage? It's trash. Why would you want to continue that? Why would you want to be around? Like, I got family in Bronx, New York. I want nothing to do with that type of environment or culture in the Bronx of New York. It's not life for me. And I was born there and I have family there. And I don't relate with it. And these are family members that look like me, speak like me, come from the same country as me. Yet we have completely different worldviews and completely different ambitions and lifestyles. So the whole assumption that Miss Jackson implies here, that because we come from the same place, because we look the same, then immediately we should trust each other and everything's kumbaya. It's delusional. It's irrational. Equally, Critical UNC's program ensures that students who don't share the same stories like John and James will interact in classes and on campus as well, thereby come to understand each other's stories, which Amnesty tells us improves cognitive abilities and critical thinking skills, reduces prejudice, and prejudice. Just simply, racial isolation that she said before, that's obviously going to increase. That is a prejudice in its own, in the concept itself. You are saying you are encouraging prejudice by preferring to be around your own skin tone and racial group. What an obvious contradiction there. And better prepare students for postgraduate life. Beyond campus, the diversity that UNC pursues for the betterment of its students and society is not a trendy slogan. It saves lives for marginalized communities in North Carolina. It saves lives. It is what? It is clearly important that UNC and other areas institution improves highly educated professionals of color. Okay, here she sprinkles it in more and then gets out of it. Like, why doesn't she just admit what she wants? You want more black people to get into these institutions because of their race. And you want them to be viewed as a handicap to lower the standard and to increase quote unquote diversity. They use all these pretty words. They dress it up for you. They use all these these general virtuous terms to make it seem pretty and ethical. Just tell us what you want, Miss Jackson. You just want black folks to get into the education system and have black privilege. You want them to have black privilege. Research shows that black physicians are more likely to accurately assess black patients' pain tolerance and treat them accordingly, including, for example, prescribing them appropriate amounts of pain medication. This is crazy, man. Why don't we have this same type of conclusion with Asians, black? What? This is crazy. This is affirming the tribalism. She just really is hard deep into tribalism and blackness and everything black, whatever. But you don't see this in Jews and Irish folks and Asian and Hispanics. You don't see this. I could care less how my doctor looks. I just want to make sure he is the best. He is competent. He is great. And even if it is true that black physicians are more likely to acquiesce, then just make it a general teaching for all doctors, no matter the race, that if you have an African American individual This is a consistent health pattern that we've learned, and you must assist them and prescribe them the proper amount of this or that. If there are studies that substantiate the differences of pain tolerance, etc., this is crazy. This is crazy to justify why we should continue tribalism. For high risk blackborn babies, having a black physician more than doubles the likelihood that the baby will live and not die. Okay, interesting. I would like to see those studies. And it's just because they're black. It's just because they're black. Oh my god, this is such a weak argument. She hasn't made a strong case of because they're black. What, black people have more of an intuition on their own people? Is it only black folks that have this intuition of truly getting into the body and minds of the black person they're trying to help? Their black patients, what I was trying to think of. Man, this stuff gives me a headache. Closing wealth disparities through programs like UNC, which beyond diversifying the medical profession, opens doors to every sort of opportunity, helps address the aforementioned health disparities in the long run as well. You know what's funny? Imagine if black folks advertised that. Like there was a billboard on the highway that says, do you know that black physicians, if you have a black baby, you need to go to a black doctor? Because black doctors will double the chances of that black baby surviving. I don't know any other race that thinks this way. I don't know any other race that comes to this conclusion. I don't know any other race that demands these type of answers to affirm their worldview of tribalism, of obsessing about race. Do not miss the point that assuring a diverse student body in higher education helps everyone. Now she has to, she made it clear what she wants, and her worldview of black this, black that, black doctors, yada yada yada. And now she has to dress it up. This is what I call dressing it up, making it look pretty, even though it's blatantly racist, and prejudice and discriminatory. There's all this stuff here encourages that. Okay, so not just those who due to their race have directly inherited distinct disadvantages with respect to their health, wealth, and well-being. Let me explain that students of every race will come to have a greater appreciation and understanding of civic virtue, democratic values of our country, and commitment to equality. The larger economy benefits too. Again, this is our dressing it up to justify racism. When it comes down to the brass tacks of dollars and cents, ensuring diversity will, if permitted to work, help save hundreds of billions of dollars annually by conservative estimates. I would love for you to substantiate that. That's a very broad claim, just general claim. Thus, we should be celebrating the fact that UNC, once a stronghold of Jim Crow, has now come to understand this. The flagship. Okay. The flagship education institution of a former Confederate state has embraced its constitutional obligation to afford genuine equal protection to applicants and by extension to the broader polity. Polity. First time I've heard that word. Polity. Polity. Interesting. I love learning new words. Polity, which means, for those that are listening, a form or process of civil government or constitution. An organized society, a state as political entity. Alrighty. So, where was I? will serve after graduation. Surely that is the progress for a university that once engaged in the kind of patently offensive race-dominated admission process that the majority decries. With its holistic review, this word here is such a funny word, review process, UNC now treats race as merely one aspect of an applicant's life. When race played a totalizing, all-encompassing, and singularly determinative role for applicants like James for most of this country's history, no matter what else was true about him being black meant he had no shot at getting in. The applicant's race-linked uneven playing field. Okay, that's the past is the past. Most of programs like UNC reflects the reality that black students have only. She's hammering that same point to justify discrimination now is because of previous discrimination we experienced. That's really what she's. That's all she's hammering the same point again. That's the underlying logic of why she's saying what she's saying here. Such programs reflect universities of clear-eyed optimism that one day race will no longer matter. Okay, so it's giving me a headache. So much upside. Universal benefits ensure from holistic admission programs that allow considerations of all factors material to merit, including race. That thereby facilitate diverse students' population once trained. Those UNC students who have thrived in the university diverse learning environment are well equipped to make lasting contributions to the variety of realms and with a variety of colleagues, which in turn will steadily decrease the salience of race for future generation. Fortunately, UNC and other institutions of higher learning are already on this beneficial path. In fact, all that they have needed to continue moving this country forward towards full achievement of our nation's founding promises. Move forward to our nation's promises. Nowhere in our nation's promises is it guaranteed outcomes. Nowhere in the promise of our nation is it about guaranteed outcomes, guaranteed prosperity. Nowhere does it say that in the Constitution. Nowhere is that now opportunity, absolutely. Free markets, absolutely. Maximizing self-governance, absolutely. Great emphasis in personal responsibility and individuality, absolutely. To our great deterrent, the majority cannot bring itself to do so. The overarching reason the majority gives for becoming a impediment to racial progress. Okay, so this now she's saying that Mr. Thomas, Clarence Thomas, is a impediment to racial progress. And she still hasn't substantiated any claims that affirmative action is doing great progress to black people. She hasn't made any, there's just no evidence for it. And also, again, I'm going to repeat myself. Did other people consent to this discrimination, this positive discrimination? That its own conception of the 14th Amendment Equal Protection Clause leaves it no other option as a wholly self-referential, two-dimensional flatness. Oh my gosh. So now she's going after how the interpretation of the 14th Amendment Equal Protection Clause. Let's read that. The Equal Protection Clause is a part of the 14th Amendment to the United States of the Constitution. It provides that no state shall deny any person within its jurisdiction the equal protection of the law. This means that the state laws must treat people in similar situation equally and not discriminate based on race, gender, or other characteristics. Not discriminate. You want to use the word positive discrimination. You're still discriminating no matter what word you want to put in front. A positive affirmation do you want to put in front of the word that's negative? The clause has been applied to various areas of law such as immigration, let me make sure. So, I mean, anywhere do you guys see? I mean, this is it right here. I mean, the Equal Protection Clause. All persons born naturalized in the United States are subject to the jurisdiction thereof, are citizens of the United States and the state wherein they reside. As you read this, ask yourself, where does it say anything um, about race-based justifying racism, correcting the things of the past, equity, opportunity of outcome or abundance of outcome, guaranteeing certain outcomes, economically speaking. Trying to figure out where it says that here, because she's saying is that its own conception of the 14th Amendment Equal Protection Clause leaves it no other option, has a wholly self-referential, two-dimensional flatness. The majority and concurring opinions rehearse this court's idealistic vision of. Okay, there it is, man. Idealism, vision of race, and you can't bend the Constitution to your ideals. That's terrible. Nobody puts you in the position of authority. The people did not put you in the position of authority to impose your idealism of what the Constitution ought to mean, that the corrections the Constitution ought to do. This is treading very tricky, terrible waters. This is, one of my mentors says, this is simply an activist judge. It's what they are. It's this activist judge. I mean, no ands, ifs, or buts about it. It's crazy. Let's finish reading this. Person born naturalized in the United States is subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges and immunities of a citizen of the United States, nor shall any state deprive any person of life, liberty, or property without due process. You can't deprive it, meaning that you can't take it away. There's no way you can do that. Life, which is your life, liberty, which is your freedom, property, which is your personal property. I'm trying to see where it says anywhere here of economic prosperity being guaranteed and discriminating against other people, judgment, obsession about race, saying the opposite here. To deny any person with its jurisdiction the equal protection of the laws. I don't see anything there to justify idealism and saying that it's two-dimensional flatness. These words are very. It's just. We don't want the courts being filled with this type of interpretation and obvious ideological activism that's being imposed into the court. This is it's just terrible. It's terrible. What's interesting is one can argue that the white Supreme Court justices that she herself was complaining about earlier was putting their ideological preferences of white supremacy and white being the supreme beings of the land and white having priority and black people being inferior, they are imposing that into the document itself. While the United States Constitution did not obviously or directly affirm tribalism. It didn't. It didn't affirm any type of race as more or less. Now, they had to have amendments to clarify and build off of that. The 13th and 14th Amendment, that is true. But the justifications and reasons behind it, the 13th and 14th Amendment, as Clarence Thomas pointed out, was substantiated by the text itself within the document that the founding fathers imposed. All right. We're almost done here. I'm tired. But let them eat cake. This is crazy. I don't know what she's talking about now. The majority concurring opinion, idealism from Brown 4 with the appropriate limit for pass indiscretion, but the race-linked gaps that the law aided by this court previously founded and fostered, which indisputably define our present reality. She's just very attached that the past dictates your future, that because of the past there's nothing that you can do. This hopelessness that this woman imposes on black people. What is this? This inferiority that she presumes and implies into black people. This need, that's all I see whenever she talks about this. Would define our present reality, are strangely absent and do not seem to matter. With let them eat cake of obliviousness, today the majority pulls the ripcord and announces color blindness for all by legal fiat, but deeming race irrelevant in law does not make it so in life, which is what the Constitution is supposed to do. Miss Jackson, the Constitution is supposed to just enforce and focus on the law of the land. As far as the life and individual rights, I mean, the Constitution shouldn't go beyond its means to impose any type of restrictions of how people should live their life and how people want to live their life. And having so detached itself from this country's actual past and present experiences, the court has now been lured into interfering with the crucial work that UNC and other institutions of higher learnings are doing to solve American real world problems. No one benefits from ignorance. No one benefits ignorance from what? Although former race-linked legal barriers are gone, correct? Race still matters to the lived experiences of all American, and this is a limiting belief. This is not true. This is only true if you want it to be true. You don't have to continue living this way. My generation and younger needs to move on from this. Race still matters to the lived experiences of all Americans. No, it doesn't. It only matters because you keep obsessing over race. Because you keep applying race defines you, and that race is the meaning of you, and that race it will dictate your future and past. It's terrible. This is the problem. This is one of the issues that needs to end. And today's ruling makes things worse, not better. You make things worse, not better. This opinion, your worldview and obsession over race makes things worse, not better. Okay, what you're saying now is doing more harm than good. This is coming from me, a black American. The best that can be said of the majority's perspective is that it proceeds from the hope that preventing consideration of race will end racism. But if that is its motivation, the majority proceeds in vain. If the colleges of this country are required to ignore a thing that matters, why does it matter though? It matters for what reason? You can say you're from Alabama and you were raised in a poor family and that you are the first one in your family to enter this college. What other information is there needed? Like, if you include race, then obviously race is being used as a privilege to make you look better, to have a higher acceptance rate, whatever it may be. This whole thing of like teeter-tottering around really what we're using race in the application process for. It's utter lies. If it wasn't a problem and it didn't create issues, you wouldn't have people taking it to the Supreme Court. If it didn't discriminate and bother other races to the point where they're frustrated and it's affecting their life, the present moment's life, the generation now's life, we wouldn't be talking now. It wouldn't go up to the Supreme Court. The best that can be said, the majority's perspective is that proceeds from the hope that preventing consideration of race will end racism. But is that its motivation, the majority proceeds in vain? If the colleges of this country are required to ignore what that matters, it will not. This is this stuff. This is passed down. This is passed down nonsense. The only way out of this morass for all of us is to stare a racial disparity unblinkingly and then do what evidence and experts tell us is required to level the playing field. Experts tell us is required. Experts like who? Are we looking at Thomas Sowell, Miss Jackson? Thomas Sowell's an expert. He debunks a lot of these so-called experts. Controversial guy, Mr. Sowell. Check out Thomas Sowell's stuff. It is no small irony that the judgment the majority hands down today will forestall the end of race-based disparities in this country, making the colorblind world the majority wistfully touts much more difficult to accomplish. So she is saying that until these discrepancies are resolved, we cannot live in a colorblind world. Yet, the thing that is holding people down most is obsession of color. As the Civil War neared its conclusion, General William Sherman and Secretary of War Edwin Stanton convened a meeting of black leaders in Savannah, Georgia. During the meeting, someone asked Garrison Fraser, the group's spokesman, what freedom meant to him. He answered, placing us where we could reap the fruits of our own labor and take care of ourselves, and to have land, and to turn it and till it by our own labor. Today's gaps exist because that freedom was denied far longer than it had ever afforded. That's true. Therefore, Justice Sotomayor correctly and amply explains UNC's holistic review programs pursues a righteous end. Here we go. Everyone else has to suffer now because of things that these people, you weren't involved in this. The past has to define you. The past, you have to suffer because of the past. The current generation has to suffer because of the past. Two wrongs make it right. That's her mentality. This is crazy. This is nonsense. Legitimate because it is defined by the Constitution itself. The end is the maintenance of freedom. Viewed from this perspective, admissions programs such as UNC are not pursuing a patiently unfair ends justified ideal of a multiracial democracy at all. Instead, they are engaged in an earnest effort to secure a more functional one. The admission rubrics they have constructed now recognize that an individual's merit, his ability to succeed in the institute of higher learning, and ultimately contribute something to our society cannot be fully determined without understanding that individual in full. There are no special favors here. UNC was thus built in review process that more accurately assess the merit than most of the admission programs that have existed since the country's founding. Moreover, in its so doing, universities like UNC create pathways to upward mobility for long excluded and historically disempowered racially groups, yet you disempower them by imposing the past problems and past traumas to them and assuming that they have to inherit. They don't have to inherit that. Now, I get it that you can say someone born into a single family and they are in Alabama, there are still plenty of avenues for that individual to leave Alabama. They don't have to be stuck in Alabama. They can get out of the area of Alabama that's very poor and lacking of opportunity. There's plenty of areas in this nation that's very, very poor. And all races, white races, there's more poor white people in poverty than there are black people in poverty. Now, in proportion of the population, there's definitely more poor black people. But as far as it be like, there are options that you have now. There are people and stories that people that have made it through and didn't allow their circumstance of their upbringing define them and confine them and restrain them. That's the assumption that Miss Jackson implies here. Our nation's history more than justifies this course of action. There it is. Key things I'm noticing as I read her stuff: justifies, idealism. In our present reality, indisputably establishes that such programs are still needed for the general public good because after centuries of state sanctioned and enacted race discrimination, the aforementioned intergenerational race-based gaps in health, wealth, and wealth. Okay, I understand that. Stubbornly persists. Okay, they persist, but you said earlier that they are genuinely, they are getting better. So is it a matter of time? Are you trying to expedite the process? Which I understand that argument. I understand that desire that you may have. Rather than leaving well enough alone, today the majority is having none of it. Turning back the clock to a time before the legal arguments and evidence establishing the sound. You've had 40 years, Miss Jackson. There's been 40 years of your way of thinking. And this is why the case has came back to the Supreme Court because people don't like it and it does more harm than good. That's why it's back into the Supreme Court justice, and I'm glad that it is. Soundness of the UNC holistic. This holistic stuff is hilarious. Admissions approach existed. The court indulges those who either do not know our nation's history or long to repeat it. Substantiate that. What? She's acting as if reversing this, that black folks are just gonna crash and burn, and that Mississippi and Georgia are just gonna go after. I mean, what? She hasn't even substantiated the claim that it's made great changes to justify positive discrimination. Simply put, the race-blind admission stance the court mandates from this day forward is unmoored from critical real-life circumstances. Thus, I mean, you have Clarence Thomas that understands that wholeheartedly and disagrees with you wholeheartedly. You know, I'm grateful that Clarence Thomas is in there because I guarantee you Miss Jackson will definitely try to play the victim Olympic excuse of trying to isolate herself as a unique individual that the court just can't understand my perspective as a black person in America. Yet an older, senior black individual came to a different conclusion than you. Time will reveal the results. Yet the court's own missteps are now both. Where was I? Hold on. Thus, the court meddled not only arrest the noble generational project that American universities are attempting, it also launches in effect a dismally misinformed sociological experiment. Time will reveal the results. Yes, it will. And time showed the results of 40 plus years of your experiment, of your solution of affirmative action, of reverse discrimination, of positive discrimination, whatever you want to say. Racism is what it is. And you yourself can't even come up with direct positive statistics that is linked directly with affirmative action being the main, if not only, reason why we see gaps closing. You can't measure that. Yet the court's own missteps are now both eternally memorialized and excruciatingly plain. For one thing, based apparently on nothing more than Justice Powell's initial say so, it drastically discounts the primary reason that the racial diversity objectives is excoriates, probably saying that wrong, are needed, consigning race-related historical happenings to the court's own analytical dustbin. Also, by latching onto arbitrary timelines and professing insecurity about missing metrics, the court sidesteps unrefuted proof of the compelling benefits of the holistic admissions programs that factor in race. Hard to do, for there is plenty. Hard to do. What? Simply proceeding as if no such evidence exists. You need, if you have evidence, you have evidence. If you don't have evidence, you don't have evidence. Don't do this whole, well, there is plenty out in the ether. Is this really a judge that we have in the Supreme Court? I mean, I get it. You know, she really has, she's well-meaning, good intentions. She obviously made clear discrepancies that we have and gaps that we obviously have in this nation. She pointed those things out greatly. But the solutions that she has is incorrect and racist, and her worldview needs to just, I hope, we need to move on from this type of world, this old worldview that has been passed down, that she inherited. That takes priority and precedence over anything else. I'm just shocked you said this. Holistic. Okay. Court sidesteps unrefuted proof of the compelling benefits of the holistic admissions programs. Holistic admissions program. Look at this. So crazy. A positive affirmation to justify racism. Imagine if white people did this. That factor in race, hard to do, for there is plenty. I'm waiting. I don't see any. Simply proceeding as such, as if no such evidence exists. Then ultimately the court surges to vindicate equality. But Don Quixote style pitifully perceiving itself as the sole vanguard of legal high ground, when in reality its perspective is not constitutionally compelled and will hamper the best judgment of our world-class educational institutions about who they need to bring into their campuses right now to benefit every American, no matter their race. This is contradictory. The court has come to rest on the bottom line conclusion that racial diversity in higher education is only worth potentially preserving insofar as it might be needed to prepare Black Americans and other underrepresented minorities. You only care about Black Americans, Miss Jackson. Let's keep it 100. All right, you only care about Black Americans. You didn't bring up anything else but Black American statistics. For success of the bunker, not the boardroom, a particularly awkward place to land. If it would be deeply unfortunate if the Equal Protection Clause actually demanded this perverse, ahistorical, and counterproductive outcome to impose this result in that clause's name, when it requires no such thing, and to thereby obstruct our collective program or progress toward the full realization of the clause premise. The clause promise. What promise? It is truly a tragedy for us all. Oh my God. The promise, where here does it say anything about justifying racism? To correct the past? Nowhere. Nowhere. Life, liberty, life, like your life, making sure your life, you don't mean as far as death and living, liberty, your freedom, property, the things you own. Which shall abridge the privileges and immunities of citizens. This is about citizenship. I'm trying to find it here. Well, I heard both sides. Try to understand Miss Jackson here thoroughly. I have nothing but respect to Miss Jackson and her achievements. That's great. She makes some pretty good arguments. She exposes the problems that we Black Americans definitely have. But her case was weak as far as the constitutionality of affirmative action, which was the main reason why it goes to the Supreme Court. I think I've really hammered everything that I need to hammer as far as this particular case. You guys can obviously tell who I agree with more and why. I explained that in great detail when I talked about let me look at this. Hold on. The result of Harvard's admission process reflects this numerical commitment for the admitted classes of 2009. Black students represented a tight band of 10%, 11.7% admitted pool. The same theme held true for other minority groups. African American. Interesting. Again, I don't care about race quotas. We don't need race quotas. We need meritocracy to take precedent over race and bragging about certain quota percentages. Anyways, guys, thank you so much for watching my video. It's a long one, almost 6 hours. I am pooped. If anybody watches this, thank you so much for watching. I'll see if I can break it up maybe to an hour each, hopefully. I don't know. But this has been fun. I've enjoyed this. You guys take care.